on the record. The record will reflect that the defendant is present with his attorney. The state is present. We're outside the presence of the jury. Now, I'm addressing the members in the gallery right now, the general public, victims, family, as well as the defendant's family members. And I hope you all pass it on to, those of you who haven't shown up yet. But I understand that there may be some tensions going on between the two sides, and I'm instructing everybody not to engage in any back and forth that's disrespectful with either side. We don't want anything that's going to cause a mistrial in this case. So please be respectful of the process. Don't make any comments while testimony is going on, and just remain calm. If anything happens, you can report it to the bailiff. Does everybody understand? Yes. Yes, okay. And I'm instructing the state and the defense to tell their people that as well. Give that information out.
Yes,
Okay?
Your Honor.
All right. Okay, let's move to jury.
All rise.
Please be seated. We're on the record. The record will reflect that the defendant is present with his attorney, the state is present, and the jurors are present and seated. Good morning, ladies and gentlemen.
Good morning.
Thank you all so much for being early. Y'all are the earliest and most disciplined bunch of jurors we know. Thank you all so much. All right. So yesterday, both sides had finished with Stephanie Campbell. Are both sides ready to proceed?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right, state call your next witness.
State call Detective Jeremy Chevalier.
Come on. Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. Statement proceed.
Thank you, Your Honor. Good morning, Detective. Could you please introduce yourself to the jury by stating your name and spelling it for the court reporter?
My name is Jeremy Chevalier. Last name is Chevalier.
Detective, if you could please tell us how are you currently employed?
I'm currently employed as a police officer with the city of Carrollton.
And how long have you been with the city of Carrollton as a police officer?
I just hit 33 years on Monday.
And what is your current assignment with the Carrollton Police Department?
I'm currently assigned as a detective in the Major Crimes Unit with the Criminal Investigations Division.
And what do you all do in that division?
Essentially, the easy way to explain is we do anything that's anything can happen to a person, any assaults. I investigate anything from harassment to robberies to shootings, stabbings, all the way to murders.
And how long have you been a detective in that division?
In this division, since about 2010, I've been a detective in some capacity for about probably 23 years.
So talk to the members of the jury about your prior law enforcement experience prior to becoming a detective. What other units or divisions did you work in?
Well, I started out in patrol. I did 5 years on the street as just a patrol officer. From there, I went to the narcotics division where I did about 3 years undercover as a narcotics detective. From there, I went back into CID, Detective Bureau, and I investigated just basic, they call it everything else, kind of ORF cases. From that point, I went back to patrol for about 5 years where I was a training officer. And then after that, I went right back into the Detective Bureau where I'm working now.
And were you the lead detective on this case involving defendant Gerardo Rodriguez?
Yes, I was.
And had you investigated homicides prior to this particular case?
Yes.
Tell the members of the jury how you first became involved in this case.
I first became involved in the case when I was called out to the scene by most likely a sergeant. I don't remember exactly who called me, but the detective who responded first was an on-call detective. We share responsibilities of answering after-hours calls within the division. So the first officer that got out there, or the detective that got out there, he wasn't prepared to work a murder. So they called me, and I called my other partners that were in that unit.
And did you respond to the scene?
I did.
What did you do when you got there?
When I got there, I made contact with the detective who was there already. He gave me the basic run-through of what he had learned up to that point. After I got the information from him, I contacted my crime scene unit that was out there already, and we walked through the crime scene. We got an understanding of what needed to be done, if they needed anything from me, and they started doing their work at that point.
When you arrived at the scene, was the defendant there?
No,
About the victim?
the victim was not there either.
And do you recall, if you don't, that's fine, do you recall approximately what time that you arrived at the scene?
I don't know exactly. It was probably maybe an hour, hour and a half after the initial call.
Were you aware that the victim had died by the time you responded?
I believe I learned that shortly after I got on scene.
Okay, so you get to the scene, kind of get briefed, what happens next?
At that point, I went back to the police department. I knew that we had a witness there, Ms. Brittany Bass, and I wanted to interview her at the police department.
Okay, did you interview Ms. Bass, or did another one of your assistant detectives?
One of my assistant detectives, Detective Bonner, did the interview with Ms. Bass. I think I came in at the very end. At the same time he was interviewing her, I was attempting to make contact with the defendant.
Okay, talk to the jury about your attempts to make contact with the defendant.
Once I arrived on scene, the patrol officers had done some great work. They had identified the potential residence of the defendant. They worked backwards from there to give me some information, which ultimately led to a phone number. So when I got back to the police department, I started to make contact with him using my department's cell phone. I sent him, I believe I sent him, I called him first, I didn't receive an answer. And I followed that up with, I believe, a text, maybe a couple of texts.
Okay, and in your voicemail, I think you maybe referred to some along the lines of this may be self-defense, but I need to get your side of the story. Why would you say something like that?
Yeah, I don't remember exactly what I said. If I did that, my ultimate goal was to get him to the police department. I wanted to talk to him. I knew we had one side of the story. I wanted to hear what he had to say. And ultimately, my goal was to have him sit across from me and tell me his side of the story.
Okay, so at the point that you made that statement, I know you don't recall exactly what you said, but had you made any decisions on the case? Had you determined that this was a self-defense case or not?
I had made no decisions on what this was other than what I had at the moment.
Okay, and backing up just a little bit, were you aware that there was a cell phone video that had been posted to Instagram by the complainant?
I was aware of that. I was shown that on the scene.
And at some point, were you able to make contact with the defendant? If so, tell the jury about that.
I did. I made, after the text, he called me and I explained to him what was going on and the fact that I needed to talk to him. He was cooperative. He told me, and things kind of went sideways or something like that. And he agreed to come in and talk to me. He said that it would take him a while to get there, and he said he would call me every so often to let me know where he was. And he did that. He called me, I think, 3 times.
And did he in fact come in and give a statement to you?
He did.
Did you explain to him before you gave a statement that he was not under arrest?
I did.
And going into your interview with the defendant, did you have the knowledge from Detective Bonner with regard to what Ms. Bass said in her statement?
Yes.
Are your interviews at Carrollton PD equipped with video recording equipment?
Video and audio, yes.
Commissioner, proceed with the charge.
You may.
State Gun Charge was marked as State Exhibit number 140. This is the DVD containing the defendant's interview that he had with you.
It is.
Do you recall what date and time this occurred?
It was well into the next morning, so I have to look at my notes, but it was several hours after.
Okay, you can refer to your notes. Don't read it out loud, but refresh your recollection and then tell the jury approximately what date and time it was. While you're doing that, the state would offer State Exhibit 140, tendering to the case.
No objection, Your Honor.
All right, State Exhibit 140 is admitted for all purposes.
Looks like it was about 2:40, 2:50 in the morning on the following day.
September 1st, 2023. Okay. Commissioner Fellows to the jury, Your Honor.
Yes, you may.
For the record, Your Honor, the entire video is about 1 hour, 31 minutes, and 28 seconds. However, there's quite a bit of open space, and so for the benefit of the jury and not wasting everyone's time, I'm gonna skip through those portions, and I'll note those times for the record. So we will start the video at a runtime of 6 minutes and 10 seconds. For the record, there is a timestamp on the video, date and timestamp of September 1st, 2023. At 2:42 and 13 hours. Before we start the video, Detective, do you see Mr. Rodriguez in the courtroom today?
I do.
If I'm seated in seat number 1, my co-counsel seat number 2, down the line, what seat do you seated in?
You would be in seat number 5.
May the record reflect this witness has identified the defendant open court.
The record will reflect this fact.
Thank you, Your Honor.
That stuff gets gone through during the day by our officers out on the street, so. Yeah, so show me in, what's the deal with the cut? Tell me where you're cut.
I think right here and right here.
We need to get,
It's not just for the question, right?
we gotta get some information on that. We'll do that real quick. All right, yeah, good to go. So I appreciate you coming in, first of all. What I want to do is I want to talk to you about what happened tonight, let you tell me what you remember about everything, and then I'll kind of tell you where we are and what we're going to do from here, okay? I'm not going to lie to you about anything. I'm not going to bullshit you. I hope you don't do that with me. I think the best course of action in something like this is to be 100% honest up front. and I think it'll work out for you in the long run. But you just gotta be truthful, okay? So before we do anything, I've got to read you your rights. Same thing you see on TV. We just have to do that since there was something that happened tonight. I have to read you your rights to let you know about them. Once we do that and get that out of the way, then we can talk. Okay?
Yes, sir.
So I'm going to read those to you so I don't mess up anything.
Mhm.
You have the right to remain silent, not make any statement, and any statement you make may be used against you at your trial. You understand that?
Yes, sir.
Okay. Any statement you make may be used as evidence against you in court. You understand that?
Yes, sir.
You have the right to have a lawyer present to advise you prior to and during your questioning. You understand that?
Yes, sir.
If you are unable to employ a lawyer, you have the right to have a lawyer appointed to advise you prior to and during your questioning. You understand that?
Yes, sir.
And you can terminate the interview at any time.
Yes, sir.
Understand that? All right. All right, that is out of the way. So, there's certain things that I know about the whole thing, but like I told you on the phone, it's one-sided. I don't know your side.
Right.
This is my partner, Detective Bonner, by the way.
Thank you, sir. Gerardo, you call me Jerry. I mean Jerry, but.
Are you from around here? Have you been around here for a while?
Alan.
Allen?
Yes, sir.
Did you grow up in Allen?
I grew up in McKinney.
Okay. Did you go to school up there?
McKinney, I moved a lot. So
Okay.
McKinney, Princeton, Allen,
Okay.
on that side.
Yeah, family lives there?
Yes, sir.
Okay. Who else is there?
Cousins, uncles, I mean.
You got direct family, mom, dad?
Mom, no dad.
Okay.
Uh,
Did you go to high school too?
went to high school in McKinney, Princeton, and Allen. Yeah, I
Wow.
moved every year.
Really?
Yeah, I was that guy.
Did you graduate?
Yes, sir.
Where'd you graduate from?
Allen.
That's the big one, right?
Yes, sir.
Yeah, okay.
For state champs.
Yeah, right.
You know, I was there with Calamari.
Yeah. Oh, yes,
Yes,
sure.
there, Calamari.
What do you do now? What kind of work do you do?
I am a broker, Freightliner.
Okay.
So I'm the guy that truck drivers or truck owners call to move lanes.
Okay.
So
That's out of my wheelhouse. So I don't know what you're talking
it's,
about.
it's
It's,
kind of those.
you gotta have trucks to get
shadows.
things, yeah.
Yeah, make
Okay.
American Rag type deals.
You worked at the same place for a while?
I got hired in mid-March, I want to say,
When did you graduate from high school?
2013.
Okay. You go to college?
No, sir.
All right, so I'm gonna kind of turn it over to you. I just want to hear your side of this before I ask any questions. Just remember, Gerard, be honest with me. Don't try to minimize things to make it seem less than what it is.
Absolutely.
You know, everybody has cell phones. There's always cell phone recordings.
I saw it.
Yeah. So just
Question, I'm sorry.
Go ahead.
Cut you off. Am I under arrest right now?
you're not under arrest right now.
I'm not under arrest at all. So I can leave if I want.
If you want to leave, yes, I would prefer you not. to
Yeah,
leave.
yeah, but I can leave if I
Yeah.
wanted to, right?
Right
I
now
can
you
just
can't,
walk
yeah.
out freely.
Right now you can't.
Okay.
Yeah. All right, floor's yours, man.
Well, I went to go get some Whataburger.
Okay.
Came back, there's a vehicle in front of me. All right,
You remember what time that was?
I don't.
You live at Guerrero, at the apartments on Guerrero?
Yes, sir.
Okay,
Yes.
what apartment number do you live in?
7-Eleven.
Okay.
Easy to memorize.
Okay, gotcha.
7-Eleven, right? Yeah, so vehicle was in my way. Well, I don't want to say my way. In front of me. Waited a couple minutes. I kind of just stood there, honked. You know, hey. I couldn't get left. I couldn't get right. He was in the center. Couldn't go anywhere.
Yeah.
The vehicle, slightly turns. Now, there's 3 parking spots, and I usually park on the back end just because there's always parking in front of the apartment buildings. Couldn't get to those, they were packed. I'm trying to get over, I'm trying to park. The guy starts getting irritated, I guess, because I told him, hey man, I'm trying to park over here.
Now, when's the first time you saw him and where was he?
I've never seen him.
Yeah, but when you saw him tonight, where was he?
He was in front of me.
In like, out of the car, or he was in the car?
He was in the vehicle,
Okay, where was he in the vehicle?
driver's side.
Driver's side. Okay.
Driver's side, a female was in the passenger side.
Okay.
Didn't think much of it. I've never seen the guy in my life. He doesn't look familiar. He doesn't. And now, from that we all know who's in what's building, things of that nature, right? I've never seen this guy. I'm telling him, man, I'm trying to park over here. I need you to move out of the way. I can't hear what he's saying because I have my music going in my vehicle. But I'm making gestures, pointing, hey, you need to go over here. I don't know what he says. He gets out of the vehicle. He starts talking towards me. I roll down my window. And I tell him, look, man, you can pick any side you want. You can pick any lane you want. I just need to get to a lane. I just want to park. That's when I see the camera, right? Oh, yeah, I got you on tape.
Is he
Okay.
outside the vehicle at this point?
At this point, steps out of the vehicle, walks around.
Yeah.
That's when he starts talking to me.
Okay.
Now, my music is still playing.
Yeah.
And I'm telling him, hey, you can pick whichever lane you want, or whichever parking spot you want. I just want to get to it.
Yeah.
I see the camera, oh, I got you recorded. Okay, that's cool, man. He starts saying some things, I don't recall what he's saying. So I park diagonal because I see vehicles going. I noticed a white van that's heading our direction. Now we're both blocking the lanes.
Yeah.
Now we're both blocking that whole lane. I try to go off to the side. I still can't park, otherwise I would have done it.
Yeah.
But I still can't park. I'm moving up to where
So were there only 2 spots, I guess, you were trying to both?
there were 3
get to?
spots. No, there were 3 spots.
Okay.
But I told him, hey man, can you pick one? Instead of him going to just a park, I don't know if he's meeting up a friend or picking someone up. Instead, let's say this is the lanes or the parking spots. His vehicle is right
Do
here,
this.
right?
You right-handed, left-handed?
I'm right-handed, but I'm a weak right now, so I should be able to do it, and I can't.
Okay, yeah.
I'm useless for it up. So he's right here,
And where's the parking spots?
right behind it.
Okay.
I'm on this side. These are the only parking spots, so there's three parking spots, covers both of them.
Okay.
I get in diagonal from him, there's a container, I'm sure y'all seen it, there's a container, right? Still can't park, but I move in diagonal, that's when I move in diagonal, just so I can let the van drive by, right? Just let them get by. There's another vehicle that was behind me that wanted to go through too. They both crossed by. I'm moving up, like I said, I wasn't about to park in a handicap spot because I'm not handicapped, right? So I move out of the way, he starts talking, okay, at that point I get irritated, I get out of my vehicle, and then he says, oh, you wanna fight? No, I don't wanna fight, I'm just trying to park, I'm just trying to go to my apartment, I just got food, I'm hungry, everybody, when you get hungry, you start getting a little irritated, right? I haven't eaten all day.
Yeah.
So I get out of the vehicle, and he starts making gestures. I don't know what he's doing. He walks over to the field. I want no problems, but like I said, I've never seen this guy, so I don't know exactly what's about to happen. He could pull out a weapon. I don't know. I come out self-defense. He starts swinging, and I hit him with my weapon.
So when you say weapon, what do you?
I had a knife,
Okay.
and I had it, and I showed it to him. He's seen it. He saw it.
Yeah.
I'm sure y'all saw it in the video.
Yeah.
I don't know what he's about to do, but he's still coming at me. So it comes at me. I hit him with it, attacked him. I got scared because I didn't know what was about to happen next, and I left.
So is this kind of a fair depiction of what you're talking about here? This is the grassy area right here. There's 3 spots. I think there was another car maybe right here. And I think his vehicle was maybe right here.
No, a little bit closer.
A little bit closer to the container, okay. So whenever you came in, were you coming from this direction?
Yes, sir.
Same direction? Yeah, so you were behind it?
Yes, sir.
Okay. So at some point, did you say you went around him? Or how did
I
it?
couldn't go around him.
Okay, so you were just behind him the whole time?
I was behind him the whole time.
Okay, you never tried to get into a parking place?
I couldn't.
Were you honking, or how did?
Like I said, I honked.
Okay, that's fine.
Yeah.
Honking's not against the law.
No, yeah, I waited though. I waited.
Okay.
I in, I waited, like I said, because people do that all the time, because I see it, you know, they pick up their aunts or their grandparents, you know. And that apartment complex has so many family members.
Right. So is that your normal parking spot? Do you normally try to get back there in the back? or
Yes, sir.
whatever?
I normally park by the container.
Okay.
By the container, if not by the container, the one next to it.
Okay,
Yeah.
all right.
You sign parking there though?
It's not assigned parking, but the front of the apartment, or the front of the buildings, those are already taken by the time I get back, to where it's like the only thing you have left is the back.
Right.
So I just, you know, finish up here.
So he's sitting there, you try to go wherever you're gonna go, you wanna go around and nothing happens. Do you end up getting out of your vehicle, leaving it right here?
No, sir.
Okay, where did you end up with your vehicle?
When he pulled in to parallel park in front of the lanes, or in front of the parking spots, when I told him that I was trying to park, and I told him to pick a lane.
Yeah.
He didn't want to, he got out of his vehicle, I ended up swerving to the left,
Around him?
around him.
Okay.
Now, mind you, his vehicle wasn't there anymore, his vehicle was still blocking,
So it was blocking all of them?
it was blocking all parking spots. I moved out of the way because, like I said, there's a van that's coming this direction, there's a vehicle behind me as well. I wasn't trying to cause any type of problems or anything. My neighbors know me, everybody around the apartment complex knows me,
Yeah.
nobody knows this guy.
Yeah.
I told him, okay, cool, he goes over here, I park to the side,
You came around him and you parked over here somewhere?
like literally in front of the container.
Parallel?
No, not even parallel, I just
Just kind of
diagonal, just enough to where I can give, the van and the vehicle behind me enough room to at least,
Facing around.
yeah, just go.
That kind of, that fair right there?
I'd say that's fair, yeah, no, yeah, absolutely,
No
absolutely.
artist.
It's very, yeah, but it's very narrow, but it's enough to let everybody just go while I'm trying to figure out where I'm gonna park.
So he gets out, he approaches your car,
Mhm.
he's
Parks
talking,
in my car.
you get out, and then you guys both walk over here.
Yes, sir.
Okay, you walk over the grassy area.
Mhm.
So what do you remember about whenever you guys got to the grassy area? What was being said? What was he doing? What was
He
it
said,
about?
oh, you got a knife? Well, I'm still gonna kick your ass, this and this and that. Okay, alright.
So, you got out, no, you got out with the knife, or was it in your pocket, or did you grab it? Where was the knife?
I grabbed it.
Okay, it was in your car?
It was in the vehicle.
Where was it in
It
your
was
car?
in the center console, and then, yeah, because, I mean, I don't know what's gonna happen. I've never seen this guy. He just
So, what kind of knife are we talking about? Describe this.
regular,
Folding
pocket knife, like, yeah,
Folding lock
black
blade, where you have
pocket
to
knife. You just
unlock
flip it up, and then it's a knife, right?
Okay.
Just your standard, you know, nothing long or anything like
Yeah,
that.
just a pocket knife.
Pocket
Okay.
knife, yes, sir. Yes, sir.
Alright, so you get out with the pocket, you grab the pocket knife, you get out with the pocket knife, you walk to where he's in the field. Does he get to the field first, or do you get to the field first, or? Y'all
That's
walk
all video, right?
together? So I've seen the video where he gets up to your car,
Mhm.
and then I heard the exchange,
Mhm.
and right before I start watching the video of the field, that's kind of when I stopped watching it. I got distracted by something else, so,
So you didn't watch the whole video?
not the whole video, no.
Okay.
I have.
I think, y'all should watch the whole video.
Okay. I will,
Before
trust
I
me.
say anything else.
Trust me, I
But
will.
I do say this, I do remember him walking in the field first.
Okay,
He knows that I have a weapon.
Okay.
He says it in the camera.
and he still,
Because I do see the
he
camera.
still goes to the
He
field.
still goes to the field, and he still comes towards me.
Okay.
Now, like I said, I've never seen this person in my life. I got scared.
Yeah.
I told him, I don't want any problems, I just wanted to park. I told him, and I told him countless times, look man, just pick a lane, just pick a parking spot,
Yeah.
okay? I just wanna park, because I live here, so I just wanna park, just go inside, I'm enjoy my burger,
Yeah.
I'll go to bed.
What's he saying?
I got work in the
Was
morning.
he yelling back at you?
I couldn't hear him because I had my music going in my car, you know, I mean, you could turn it to 20% volume or whatever, and you still won't be able to hear him from outside. But he was coming at me aggressively. Then he started pointing at, I believe he was pointing at the female that was in the vehicle. I don't know who it was. I don't want to, you know, say it was a girl or anything like that. But he was pointing, oh, you got the camera, blah, blah. Okay, that's fine. Can you just pick a spot? And I don't know if he was just having a bad day. I don't know if pick someone up or anything like that. After that, he went to the field. He saw the weapon in my hand.
Okay.
I warned him. I still walked up. I warned him. I showed him.
Yeah.
And he still wanted to come at me. I didn't know what was going to happen. I didn't know if he was going to pull something out or anything like that, or if the person that was in the vehicle was going to do the same thing.
Was he acting like he had something, or were you just concerned that he might have had something?
I don't know. He just came towards me. He could have pulled something right then and there. He could have, I don't know. I don't know what's going to happen. Because I've never, I'll tell you this, I've never experienced, what happened tonight, I've never experienced in my life. Ever. I'm generally a very good person. I just work, I take care of my kids, I take care of my dogs. I live a pretty quiet life, right?
Yeah.
Your standard American life,
And then
right?
suddenly.
And then it's one of those things that it just,
I get it.
Did he shove you, hit you, did he come at you? You said he came at you. What
he
was it?
swung, I remember him swinging. I ducked down. Now, mind you, he's tall.
Yeah.
I'm sure y'all seen from the video, he's pretty tall, so it didn't take much for me to duck down because I'm pretty short, as y'all can tell, right? Didn't take much for me to duck down. I ducked, and then that happened, and I was scared for my life. I thought something was gonna happen. I saw him hit the ground, and then I saw him get back up. I didn't know if he was gonna pull out a gun.
Yeah.
I ran to my car, and I took off.
Yeah.
So,
And just to be clear,
mhm.
you didn't see him with a gun, but you're concerned that he might have something.
I'm concerned for my safety. I'm not concerned about what he has,
Yeah.
but I'm concerned for my safety because, like I said, that moment, it's like everything flashed before my eyes. My kids, my life. It's 2023, right? I mean, I'm sure y'all seen it. I'm sure y'all, you know, you don't know what's gonna happen.
So let me ask you, Gerardo,
Mhm.
what do you? I mean, you had options before you got out of the car. Could you have done something different?
I don't know. My only concern was, like I said, was there was a stranger at the apartment complex who no one has ever seen.
Yeah.
I'm sure y'all talk to people around the apartment complex, no one has ever seen this individual. I just wanted to park, like I said. Tall person comes up to your vehicle, road rage. I'm sure y'all heard it, seen it.
Yeah.
My only concern was my safety
Yeah.
and defense.
Why didn't you just drive off? Why didn't you just leave?
Leave my
Like-
property, because I
no,
pay
no,
taxes.
I get where you're coming from.
Okay,
I-
okay.
Devil's advocate, why didn't you just drive off away from the parking spots? I mean, there were other parking spots right around the dumpster area.
How could I?
Drive off?
Yeah, how could I drive off?
Well, you
He didn't
could just-
move.
Well, yeah. but
By the
you-
time I honked, he got out of the vehicle
Sure,
and came and attacked
But
me.
when you drove around and parked, you weren't in a parking spot.
Right,
Why didn't you
that's
just-
illegal.
Why didn't you just keep driving though? Why didn't you avoid the confrontation that was about to happen?
Because I-
We've been asking the
When
same
he-
questions to him as well.
Yeah, okay, so, he got out of his vehicle, I could have driven off, he could have shot, I don't know. He could have had a weapon, like I said, he could have had something. I could have taken off, boom, bullets in my car, I don't know.
And
I mean,
again, I'm
like I
just
said,
trying to get into your mind and try to figure out what was going on. I mean, obviously, to me, and I wasn't in your position, but, I mean, the safe thing would be, instead of parking and engaging with this guy, because obviously he's aggressive, just drive off to the other part of the complex.
But you don't know that, we don't know that until it actually happens.
But yeah, there's an unknown.
Yeah.
And I
Yeah.
don't wanna argue with you about that,
No,
I'm
of
just,
course,
I'm
of
just
course.
asking questions, I'm
Mhm.
curious.
Yeah.
Do you remember so you're right-handed, you had the knife in your right hand, how many times did you hit him with the knife? Do you remember? How many times did you stick him with the knife?
Did y'all watch the video?
I didn't watch that part, I'm asking how many times do you think you hit him with the knife?
Well, I don't think I did. I mean, like I said, I was protecting myself.
Yeah.
He came in and attacked me.
Okay.
I defended myself, and I ran away because there's no telling what's gonna happen.
So, earlier you just said that you swung with your weapon.
Mhm.
Were you aiming for anything, or were you just
I closed
wildly
my
Did
Yes, sir.
you cut your hand on your own knife, or was that something on the ground? How did you cut your hand?
I cut my hand on my own knife, I mean, I got scared.
How do you think that happened?
I don't know, I grabbed it wrong, I mean, I've never used it, I've never used it.
Yeah, no,
I've never had to,
it's a crazy situation.
it's plain self-defense, it's like if you were to have a weapon, or a gun, for example, you don't know how to use it, you're just gonna close your eyes and pray that you hit your, whoever.
That's reasonable.
Right.
Yeah, unless
So-
you're trained with it.
Yeah, exactly.
Yeah.
I wasn't trained with it, I only kept it there, I've never used it, I've never had to use it. And.
Do you think your hand slipped down onto the blade whenever you were going,
I think it did.
like 5 minutes, slipped down onto the sharp part of it?
Yeah, my hands were like butterfingers, and I grabbed it wrong, my guess is like,
Yeah.
I held the actual blade.
Where is that knife at now?
Oh, so.
Did you toss it somewhere, or?
Yeah, I mean, do you want it?
Oh, it'd be nice to have it.
No? I mean,
Could you get it back?
I probably could,
Okay.
maybe.
Where is it? Where'd you put it?
I don't remember, I left, I took off, I was crying so much, I was crying so much that I couldn't bear, like, I looked at myself and I'm like, who am I?
Yeah, boy, yeah.
Yeah, like on my shorts and everything, and
Did you, let me ask you this, did you throw it out the window, did you put it in a trash can?
just threw it out there, and I just,
If I asked you where, would you be able to tell me where you threw it out the window?
I couldn't, no sir,
Okay.
I'll be honest with you.
What made you decide to throw it out the window?
I didn't know what to do. Like I said, I was nervous. I was scared for my life.
Yeah.
I didn't know what to do with it. I didn't know what to do with myself. I know that. I know
So
that
if you didn't know that you stabbed him or hit him with a knife, why would you throw the knife away?
because there's no reason for me to have any type of weapon. If I'm gonna get hurt, if I'm gonna get put down, then if it's my time to go, it's my time to go. I have no eventual.
Yeah, but I don't understand why you got rid of the knife. If you weren't sure that you even cut him with it, why would you get rid of the knife? And if it was
Because it shouldn't be like, I shouldn't have to defend myself in that type of way. If something's gonna harm me, then it's gonna harm me, right?
Yeah. Okay. So where'd you go after that? Where'd you go after all this
I
happened?
just drove off.
Okay.
I drove and,
Go to a friend's house or talk to anybody?
no, I just drove off. I was panicking.
Yeah.
I went to a Walmart, the Walmart in Carrollton, or the one right here.
Frankfurt.
I think so. It's the one by the Waterbury that I went to.
Okay.
What
What'd
did
you do
there?
Marsh or the one over, or the one over North Georgia?
Yeah, just rub out.
I'm not familiar from this area, but
Yeah.
the Waterburger, the one the Waterburger that I originally was at.
It's over. There's a Wendy's over there as well.
I didn't see a Wendy's, so I was over down there, but, so I went to Waterburger, and then across the street is Chevron, is it? Right? I mean,
Oh, didn't, but I think this was.
yeah, it's somewhere down there.
So what'd you do at the Walmart?
I just stood there.
Did you go inside, or?
No, I didn't go inside. I was
You
just-
sat in the car?
I sat in the car, I was panicking, and
Call anybody, talk about it.
just froze. I didn't know what to do. That's when I believe I got a text from you. My phone,
Well, I didn't text you until like 4 hours after.
right, yeah, but
So,
I was trying to.
so what'd you do between Walmart and when I texted you? Because that's like a 4 hour window.
Yeah, I stood there, I took a nap, I mean, I couldn't go back home, I didn't wanna go back home, I was too terrified. And I stayed there, I got out of my car, I sat on the curb, and, yeah, I couldn't do anything, there's so much I could do.
So where's your car now?
Expect me to run accomplice.
When did you go back to the apartment complex?
You wanted to meet up, and I didn't want my car to get towed or anything.
Yeah, that's great.
So I just.
Like right before you came here?
Correct,
Okay.
yeah, I just drove it, placed it there, got picked up, I let you know.
Yeah.
And then I,
Okay, so your ex-girlfriend out in the lobby, is that who that is? Girlfriend, ex-girlfriend? And she said that's what it was. I'm
yeah,
just- what's your impression of what that relationship is?
she's just someone that dropped me off over here,
Okay.
and who cares about me.
Okay. Did you go to her house or did she meet you somewhere?
No, sir, I told her, hey, I'm gonna leave my car over
Yeah.
here, and I need you to take me over here.
Okay.
All right, and she said, okay. She left her dog at her place, and she picked me up and dropped me off over here.
Okay.
Well, came with me.
Yeah, okay. All right. Anything else you think of?
No, at the moment, we got, well, we're supposed to have anything on it because we have lots to do, so we'll look at that video,
Yeah,
certainly.
yeah.
But we always like to get everybody's, hey, tell me what happened, because we have to hear their own words before we ever even get all the way through all the evidence, like, you know, what happened.
Yes, sir.
It's important to get that down. Do you have any questions for us?
Okay. So what I'm gonna do, before we do anything else, I gotta get some photos
Mhm.
of your hand.
Okay.
I can definitely get some medical attention for you if you think that's something we need to do.
A little US corn, I guess, wouldn't hurt.
I mean,
No.
you might need a stitch or two.
Stitch or two.
I mean, we can,
As long as I'm not held in here.
yeah.
Let me go, I'm gonna talk to my boss, cause he's doing some things while we're talking. Let me get my crime scene person in here to take some good photos of that, and then we'll come back in here and give you the rundown of what's going on.
Okay.
Fair enough?
Yeah, so am I gonna get medical attention right now, or?
Yeah, I would like to see you get some medical attention right now, so. Give me a few minutes, let me gather some stuff out here, I'll come back in and talk to you and let you know what's going on. But I want to get the photographs first, okay?
Sure.
All right, just hang out here, I'll be right back.
For the record, stopping the video at a runtime of 35 minutes and 0 seconds. We're gonna skip forward to 1 hour and 35 seconds. And just for the record, during this time, the crime scene person comes in, takes photographs of the defendant's injuries, and takes a swab of his hands. So that's what's taking place during the point in time that we're gonna skip through. I'm gonna restart the video at runtime of 1 hour and 35 seconds.
Job to tell you that this guy has died.
No.
He, whatever happened during the night, you end up hitting him in the chest with a knife, and it went into probably his heart, and he died as a result. They rushed him to the hospital, he died. So you are, you're gonna be placed under arrest tonight for murder, okay? I don't think I have any more questions for you unless you wanna talk any more about anything you think is important for me to know.
Can I talk to my girlfriend?
She is probably gone.
Did you let her know?
We went out and talked to her. I don't know that they told her what happened. But we told her that you were probably gonna have to stay with us.
Is there a bond set or?
No, not yet. We're still working on all that. I would like to ask you before we go to all the trouble of doing a lot of searching and everything, I really wanna get the knife that was used. Is that thrown away or did you put it back to your house?
It's not in my house, I don't remember what I said.
Okay. And you think you just tossed it somewhere? Not in a trash can or dumpster anywhere?
No, sir.
Okay. And you don't think you'd be able to show me where that is?
I could, maybe,
Do you think it hit the road, or do you think it hit some grass?
bush, yeah.
How far outside of your complex do you think you threw it, or did you throw it in your complex?
No, it wasn't in the complex, no, sir. It wasn't in the complex.
Were you driving as you did it, or? I mean, at this point, Gerardo, it's not, I mean,
I'm sorry, I can't believe it.
Yeah.
I can't believe it.
and I know, I'm laying a lot on you right now. And I know that you didn't know that this had happened, but, the knife is important for a couple different reasons. The knife is important for you, just to show that you're cooperating with everything.
Like I said, I just defended myself.
Yeah.
I just,
And Gerardo, I have nothing to take away from that, from you. I can't argue with you about that. There are just certain things about this that are weird. I certainly don't think you're a bad person. Obviously, I don't. But there's some things that I'm gonna have to go back and look at and rewatch and work through in my mind, to be able to give the DA a good case, okay?
against me?
Well, you're the only one charged with murder, Jordan. I'm not against you. I'm representing the state at this point, and I've gotta put together all the facts. I'm not putting a case together against you. I'm putting a case together that consists of facts about what happened tonight. Like I said, I don't think you're a bad guy. I think you made a mistake. But sometimes.
Yeah, like I said, we're not a judge or jury.
Yeah, I understand.
We're gathering facts, that's what we do, and again, like he said, you know, after we talk to you, look at everything else we got.
So you know what's the video?
Most of it, yeah. I wasn't lying to you when I said I didn't see all of it, because I got called to do something else. If I had to go and get the knife, where would you suggest I go and get the knife? I'm trying to avoid interrupting your dogs with a search warrant in your house.
Oh, I mean, like I said, you can go in the houses.
I know, I would rather not do that though if you've got dogs there.
We're
Because,
doing it great.
yeah, it's just gonna,
Anyways, I mean, long story short, it's not in my apartment, it's not in the, complex.
If we could find it, that would probably help prevent us from having to do all that.
We want that out.
As far as having to go through your apartment, go through your stuff, so,
That's what you can.
yeah, which we don't really appreciate
I
that.
would rather not do that. I would rather go get the knife and be done with it.
Yeah, or,
Then, like I said, the knife, I mean, getting the knife shows that you're cooperating, that you're telling us where things are. The fact that you got rid of it because you're scared, but now that you're not scared. I mean,
No,
you're
I'm still scared. No,
You're
I'm still scared.
I'm talking about it in the moment, though.
Yeah.
This is a different kind of
Scared
thing.
24/7.
But the fact that you're telling us where this is just lends a little bit of credibility to your story.
we don't want to certainly say your apartment, your girlfriend's place, or all that stuff.
There's Top Golf, in Frisco.
On 121.
We're on the highway.
Let me ask you this.
BNT, Dallas Motorway.
If you rode with us,
Bush.
if you rode with us, would you be able to show us where it is?
Yes, sir. 90% sure.
Okay.
Okay, but it's worth a shot, I believe. I feel like I can picture it in my head,
Okay.
if that's okay.
That's fine. I'd rather do that than have to go rummaging through your house looking for a knife
Yeah.
that may or may not be there. All right, let's do this. Let's get you some medical treatment on your hand.
Okay.
We can at least get some bandages, and then we'll do that.
Sure.
Okay? Okay.
Very good.
Okay. You got any questions for me?
Where am I gonna be staying?
You're gonna be here in Carrollton.
Okay.
I'm gonna put what's on the police on you because I'm gonna have to come back and get a DNA swab from your mouth, but I'm gonna get a search warrant for that. I don't wanna,
So
I'm gonna walk you through this, bro.
Yeah,
I'm not
because
I'm not gonna leave you out.
I feel like this isn't happening.
Believe it or not, I've sat across from people like you before. Like I said, I don't think you're a bad guy. I think you just got caught up in something in a bad way. But I think the more you cooperate on the front end, the better it'll be for you in the long end. Okay. So, it's all right. Don't apologize to me. It's a tough spot. Okay. Let me go get the medics to come look at that, and
Can I make a phone call?
absolutely, yeah, I'll let you do that. Logistics, I'm gonna try to figure out what we're gonna do, if we're gonna bring you right back to, get you booked in, or else, or if we're gonna ride out to get the knife.
Okay.
I'd rather do that first.
Change of clothes?
Yeah,
or or-
I'm gonna get, they're not a fashion statement, but they're, okay.
That'd be great, yeah, and, you know, I didn't wanna go home and change, I just like, I don't know what this is mean.
It says a lot about your character that you called me back and you didn't change clothes and you didn't try to get rid of the clothes. I wanna keep that going though by going and grabbing the knife before somebody else finds it.
Yes, sir,
Okay.
yes, sir.
Alright, give me just a second, okay?
Okay. When could I make my phone call?
You wanna get you treated first?
Okay.
And then you
And
can make
if you have some hand sanitizer, I'll still want.
We'll take care of that.
Okay.
Let's get a medic. Get some medics.
For the record, stopping the video at a runtime of 1:09 and 0 seconds. We'll skip forward to 1 hour, 22 minutes and 35 seconds for the record. In between that time, the medics come into the room and treat the defendant's the wound to his hand. Started 1:22:26.
This is
No,
okay, this was in the back of your car, so they took it,
no,
thinking that was it, so.
no.
Okay, I just wanna make sure. I think I may have a workaround for going out and searching and all that kind of stuff.
Like I said, I can go with you, but,
And we'll probably do that, I'll talk to you in a second.
okay, all right.
For the record, stopping the video at 1 hour, 23 minutes and 0 seconds. Really quickly, before we continue with the video, Detective Chevalier, that may have not been clear, those few seconds. What was that you were doing that you showed the defendant when you walked into the room right there?
Some other detectives had gone out and talked to the girlfriend, and when they searched her car, they found what looked like I guess it was a box cutter or a short blade knife. And I just wanted to clarify with him if that was the knife that was in the car, and he said it wasn't.
Okay. And when you say the girlfriend, you're referring to the defendant's girlfriend?
Yes.
And was it your understanding that this girl, do you remember her name?
I don't.
Tanya Mendez?
Yes, that sounds familiar.
Was it your understanding that she brought him to the police department for this interview?
Yes.
Okay. And is it your belief that that particular weapon or box cutter knife, whatever it was that they found, was it the murder weapon in this case?
No, I don't think it was.
So for the record, we're going to go forward to 1 hour, 25 minutes and 45 seconds. And in between that time, I believe the medics come back into the room and further assess the defendant. We started runtime 125 and 42 seconds.
Oh, yeah. All right, here's what we can do. What we'll do is, if you're okay with us going in the department, you and I and Detective Bonner will drive over there together. We'll do this is called a voluntary consent to search. That will just allow us to go in and look for the knife. If you say it's not there, we just have to check that box, okay? Once we're done with that, we'll let her go in and take care of the dogs, whatever she needs to do with the dogs.
Is she in there right now?
Not in your apartment now. She's here. She's still hanging around. We asked her to hang around. Because I want to do some things that kind of help you out a little bit. I don't want to just like put you back there and forget about the dogs or everything. But I do want to check all those boxes first. And then once we're done with that, we'll do the drive. Are you confident that you can take us to where you think you do that night?
I think so.
Okay. All right, well, let's do this then. I'm going to fill this part out, and then we'll head over there and do that. Number 711. All right. It doesn't have to be neat, but I do need you to put a signature right here, just saying this is what
Do
we
my
do.
best.
It doesn't have to be fancy. This is a little, that's fine, right there. This says that you understand that we're not forcing you to do this, and at any time, if you want us to stop doing it, you just say the word, and we're gonna stop it, okay? But like I said, all we're doing is trying to check the box, and, it's all gonna be recorded to show that you're being cooperative with us, and you're doing everything you can to try to get this, get out in front of this thing, okay? Alright, so let's head out. I'm probably gonna put handcuffs on you, I'll probably put them, I'm probably gonna put them on the front, yeah.
Okay.
That's okay.
Yeah, it's okay with me.
Hey, we're making a roll. Well, I think that's probably best.
You want this other one?
You
How much
take
left
it.
do you-
Yeah, I'll get you another one.
You could.
Do you need to pee again?
I'm good.
Okay, sure.
Yes, sir.
For the record, stopping the video at a runtime of 1 hour, 30 minutes and 0 seconds, and nobody enters the room after this time. So Detective Valier, we'll come back and address some of the specific things the defendant stated to you in his statement, but let's walk through the rest of your investigation and we'll come back to that, okay? But let me ask you this, based on your contact with the defendant at the time of the statement, did you form the belief that he was intoxicated or under the influence of anything at that time?
I didn't notice anything at that point.
Okay, so talk to the jury about some of the follow-up after we saw this video. What happens after this?
So after we left the interview room, we did what's called a down and out. We basically take the defendant on the drive to try to get him to recollect where he tossed the knife. We took the route that he said he took, and we drove to the Topgolf in the Colony on 121. And we sat in the parking lot. I was in the driver's seat, he was in the passenger seat, and my partner, Detective Bonner, had the job to go search bushes. We sat there for 30 minutes, and Mr. Rodriguez would tell us, well, it's got to be in this bush. My partner would go crawl into the bush, we'd go to the next bush, and we never found the knife in the parking lot where he said it was.
Okay, do you recall, was it still dark when y'all were looking for the knife?
It was dark.
Did y'all make further attempts to go back and try to find the knife during daylight
Yes.
hours?
Other detectives went back out and weren't able to locate the knife as well.
Okay. So there's no knife to present to the jury today?
No.
Okay, what happens after that?
At that point, we take Mr. Rodriguez back to the jail and book him in for murder.
Did you all, at the end of the video, there's some discussion about possibly going to the defense department?
That was done before we went out to Topgolf. We drove to that location. We had a couple of other detectives that had come into work by then, and they did the search of the apartment.
And as we saw in the video, the defendant gave consent initially to search his apartment, is that correct?
He did.
But at some point, did he retract that consent?
He did.
And did detectives leave his apartment at that time?
Yes, they did.
To your knowledge, was anything recovered, seized from his apartment?
No.
With regard to tracing the defendant's steps as it pertains to what he said that he went after he left the scene, did you do any follow-up on that?
I did.
What did you do?
I wrote search warrants to his cell provider, and I was able to obtain the cell tower records for his whereabouts that evening.
Did you analyze them, and if so, what did they tell you about what his whereabouts?
Objection, Your Honor. This answer necessarily requires hearsay. He's referring to cell tower records that were obtained from some third-party organization that he's not even identified at this point. Even if he did, he's not the proper witness to introduce this evidence at this time without proper authentication and a witness from that organization that can speak to the methods and reliability of that evidence, Your Honor.
And what's the state's response?
I can ask a few more questions, Judge, to lay the foundation.
Lay the foundation. Otherwise, defendant's objection will be sustained.
Okay. Do you recall the defendant's cell phone provider at that time?
It was T-Mobile.
Okay. And you said you wrote a search warrant for those records?
Yes.
And do you recall when you received those records?
I don't. It would be on the search warrant. I don't have a copy of that.
This time I'll move on, Your Honor. You're not coming back. All right, so let's go back to the defendant's statement. And let's kind of start from the beginning. He told you that he pulled behind the complainant's vehicle and he waited a couple of minutes and he honked his horn. Do you recall that?
I do.
From looking at the security cam video, does that appear to be true?
Not from the camera footage, no.
Based on the video, it appears as though the defendant pretty much immediately pulls around the vehicle and then cuts off the vehicle. Is that correct?
That's what it looked like to me.
And the defendant also stated that the complainant, Mr. Mill, was in the driver's side of the vehicle. Is that correct?
He did say that.
And that the female he's referring to, Ms. Bass, was on the passenger side. Is that right?
That's right.
Was that correct or incorrect?
That was incorrect.
He also stated that he could not go left or to the right because the complainant's vehicle was blocking the lane and he could not move forward. Was that what he stated?
That's what he said.
Was that true based on the video?
No, it was not.
He has also stated that he had never seen the complainant before in his life. Is that what he said?
That's what he said.
Were you aware that, based on Brittany's statement, that the defendant had actually met the complainant before from living in the apartment complex?
Your Honor, I would object under two grounds here. First of all, it's hearsay. Second of all, it is speculation. He cannot say for certain one way or another whether the defendant had ever seen Mr. Mills before, or whether his recollection at that time was that he had not seen Mr. Mills. So he's going into the mindset of our client that requires speculation, and he's relying on hearsay statements to do that.
Thank you. What's the state's response?
I respond that this is information that was garnered during the course of his investigation that he used. In the course of his investigation, he has already testified that he had received this information from Detective Bonner going into this interview, and so he was aware of this information, and so it was a factor that he used in his questioning of the defendant. And so, as it pertains to hearsay, this was information that was gained during the course of his investigation.
May I reply, Your Honor?
Go ahead.
First of all, if Ms. Bass told Mr. Bonner and Mr. Bonner told this detective, then that's hearsay within hearsay, so we still have an issue there. Second of all, if he's using it for information relied upon in the course of his investigation, that means he's using it for a non-truth purpose. If it's a non-truth purpose, then I would argue that under 401, it's irrelevant, and under 402, it's inadmissible.
All right, your objections sustained.
The defendant also stated that when he was in his vehicle and the complainant, Michael, was talking to him, he said that he could not either hear because his music was up, or he could not, he doesn't recall what the complainant was saying. Do you recall that?
I heard it, yes, I do.
It appears as though, as you're talking about the position of the vehicles, that you're drawing a diagram in the interview room. Do you have that today? Did you keep that?
I did not keep that.
Okay. The defendant also stated that he, because the complainant was talking to him, that he began to get irritated. You remember him saying that?
He did say that.
He also stated that he was hungry, he hadn't eaten all day, and he was irritated by that as well.
Correct.
Is that correct?
That's correct.
He also states that because of this irritation, that's when he got out of his vehicle. You recall him saying that?
That's right.
Up to that point, had he ever stated to you that he was in fear of the complainant at that time?
No.
He states that the complainant started swinging at him, that he ducked, and then at that point in time, that's when he strikes, and I quote, he says, "I attacked him." You remember him saying that?
He said he swung at me and I ducked.
And at that time, that's when he, in his words, he hits him with his weapon, referring to the knife. Is that correct?
That's correct.
And in fact, again, and I can play it again for you if you don't recall, he says, "I," referring to himself, the defendant, attacked him, referring to the complainant.
He
You
did
remember
say
that?
that. He did say that.
It's at that point, we first hear him say that I got scared, but this was referring to after the stabbing, correct?
Correct.
He says, "I got scared because I didn't know what to do, and then I didn't know what was about to happen next, and I left." Do you recall that?
I do.
He also admitted that there was no assigned parking there, correct?
That's correct.
So he would not have been entitled to any specific parking in the parking lot, is that right?
That's right.
He claims that he showed the complainant, Mr. Mills, the knife prior to going into the field, and that the complainant responded, "Oh, you got a knife, well, I'm still gonna kick your ass. This, and that." You recall him saying that?
I'm going to object to leading.
I'm sorry?
I'm objecting to him leading this witness. These are not open-ended questions. These are yes or no questions, which is not appropriate for direct examination. If he wants to reframe them into appropriate examination question, then we would not have an objection. But this time, the formal objection is to leading the witness.
Overruled.
Do you recall the defendant telling you that the complainant said to him, "Oh, you got a knife, well, I'm still going to kick your ass, this and that." You recall him saying that?
I do remember that.
He also stated that prior to getting out of the vehicle and walking to the field, that he grabbed his knife from the center console.
He did say that.
Your Honor, I'm again
I'm sorry,
going to object to leading.
I'll rephrase the
If
question.
we
I'm
can have
sorry.
a running objection, if he's gonna continue to answer us these
You
questions.
get your running objection.
Thank you.
I'll rephrase the question, Your Honor. I'm sorry. Do you recall the defendant telling you that when he got out of his vehicle, he grabbed the knife from the center console?
I do recall that.
And do you also recall stating, the defendant stating that the complainant, Mr. Mills, wanted him to get out of the vehicle to fight him, and that would have been prior to him arming himself with the knife?
Correct.
Do you recall the defendant telling you he just came towards me, he could have pulled something right then and there, he could have, I don't know what was going to happen?
I do recall him saying that during the interview.
Do you recall him saying, the defendant I'm referring to, do you recall the defendant saying, "It didn't take much for me to duck down because I'm pretty short"?
Yes, I do remember that.
Do you recall the defendant telling you, "I'm not concerned about what he has," when you ask?
Your Honor, in addition to leading, this is needlessly cumulative. The jury has has the interrogation video. We just watched it in its entirety. It seems needlessly cumulative to rehash every statement that was made in the video that the jury just watched with this witness.
Thank you. Your objection's overruled.
Thank you.
Do you recall the defendant telling you, "I'm not concerned about what he has," referring to the complainant? When you asked the defendant, did you see the complainant with the gun?
He did say that.
Did the defendant tell you at any point during the course of the interview that he saw the complainant with a weapon of any kind?
He did not say that at all.
At some point, the defendant asked you, had you watched the video? Do you recall that? And there was reference to maybe a video showing the actual offense, the stabbing. To your knowledge, is there any video showing the stabbing in this case?
No, there's no.
Okay, so as it pertains to that talk about the video, what was your intent in that conversation about the video with the defendant at that time?
Just to elicit a response, I wanted him to know that we did have a video. At that point, I had not seen the entire video. I was hoping that there would be more to it, but there wasn't.
At some point during the course of the interview, you asked the defendant, obviously, what he did with the knife, and then he gives you, well, you asked him specifically, "Why did you get rid of the knife?" And then he gave a response. When you asked him that question, did you recall the defendant stating, "Because there's no reason for me to have any type of weapon. If I'm going to get hurt, if I'm going to be put down, then it's my time to go, it's my time to go. I have no weapon, shall," when he trails off. Did you understand that? What did that mean to you?
No, I didn't understand that. It was very confusing.
Do you recall the defendant telling you that he does not believe that he hit the complainant with a knife? In other words, that he didn't injure the complainant with a knife?
He did say that.
Detective Schweider, during the course of your investigation, besides Brittany Bass, were you able to identify any other witnesses that either observed the events leading up to the stabbing or the stabbing itself?
No.
Crime scene collected swabs from several of the blood stains at the crime scene. Was any of that evidence submitted to the lab for further DNA testing?
No.
Why not?
At that point, we generally will do that if we don't know the identity of the suspect or victim. And at that point in the investigation, I knew both the suspect and the victim.
Based on your investigation of this case, were you able to determine or come to an opinion as to whether or not the deceased, Mr. Mills, made it out of the grassy area to either the curb of the parking lot or to the parking lot area?
I don't believe he did. I don't believe he made a grass.
So, with that information, would it be feasible to you that the complainant's blood would be either at the curb or in the parking lot?
Your Honor, I'm gonna object at this time. This is the same objection the state had when I asked the same question of the CSI individual yesterday. He has provided no training or experience in crime scene reconstruction. He had the opportunity to test the DNA, he didn't. It would be pure speculation on whose blood is what at this time, so we would object to speculation.
Thank you. What's the state's response?
This is not crime scene reconstruction, Your Honor. The crime scene person only had a limited role in this case. This is the lead investigator. He has all the information in this case. He's already testified that based upon his investigation of this case and his knowledge of this case, that he believes that the complainant did not make it into the parking lot. So I'm not asking for him to give a scientific or technical or expert opinion as to this blood. It's based upon the information he has. Does he have an opinion as to whether the specific blood in the parking lot or on the curb of the parking lot is the complainant's blood?
Thank you.
Your Honor, if he's not asking for an opinion that would be relevant to the fact finder, then I would object to that. He is speculating as to whose blood is what. He had the opportunity to determine that answer and he did not. And therefore, I would, object under speculation.
Thank you. Objections overruled. Go ahead.
So the question, Detective, is it feasible that if the complainant did not make it out of the field area, is it feasible that his blood is in the parking lot on the curb to the parking lot?
I don't believe that's his blood in the parking lot.
With regard to the defendant's vehicle, you obtained a search warrant for that, is that correct?
That's correct.
Can you talk to the jury about that process?
Writing the search warrant, it's just a matter of presenting the probable cause affidavit to the judge. She signed the search warrant, and I had other detectives execute that search warrant on the vehicle. The vehicle had already been towed from the apartment complex to our crime scene Sally Port, so it was there readily waiting for us for the search.
Would you say that the defendant was cooperative when she made contact with him?
Yes.
So ultimately, you decided to arrest and charge Mr. Rodriguez with the offense of murder, correct?
Correct.
Did you come to that decision alone?
Ultimately, but no, it was we had a lot of detectives there that night. They all watched the interviews. They had the exact set of circumstances that I had, and we all came to the same conclusion that we should charge him murder.
Okay. Now, obviously, the defendant claimed in his interview with you that he acted in self-defense in this case, but you all still came to the decision to charge him with murder, correct?
Correct.
Why is that?
Because we didn't see that there was any self-defense evidence.
Your Honor, I'm going to object that he's not qualified to make that determination or opinion. He has not been proffered an expert in any way on self-defense, the laws of self-defense in Texas, and we would ask that that answer be redacted and stricken from the record, and the jury instructed that he is not qualified to make the determination of self-defense, and that he's invading the province of the jury, that is their decision to make, not his.
Thank you. What's the state's response?
We are not offering Detective Chevalier as an expert in self-defense under Rule 701, Texas Rule of Evidence, opinion testimony by a lay witness. If a witness is not testifying as an expert, testimony in the form of an opinion is limited to one that is A, rationally based on the witness's perception, and B, helpful to clearly understand the witness's testimony or to determining a fact issue in this case. The defendant, Detective Chevalier, has already testified that not only was he the lead investigator in this case. He has previously investigated other homicide cases. And so I believe he has the experience to give an opinion in this case. That's first. Secondly, he made the decision to charge the defendant in this case. And so with those things said, I would ask the court to be able to give, him to give a lay opinion in this case as to whether or not self-defense applies.
Thank you. Any further objections?
I think even based on the state's response, he's fully qualified to determine whether or not this could potentially meet the elements for murder, but there's nothing in here that has proffered him. I mean, if he's a lay witness, then it's not relevant and it's not appropriate for him to make a final decision on the ultimate opinion or the ultimate issue under 704 in this case. Yeah, so Your Honor, under 704, 701, 702, 703, and 705, I object to the opinion. And furthermore, that it's speculation and should not be admitted.
Thank you. The objection's overruled. The jury will assess the weight to be given to this witness's testimony.
Thank you, Ms. Hammond. I'll pass the witness, Your Honor.
Defense,
Yes, Your Honor. Detective Chevalier, I guess let's start where your direct examination ended. You said that you and lots of detectives watched the videos, reviewed the evidence, and that y'all made the determination that this was murder.
Correct.
Okay. But in the video, we see that you arrest him for murder and charge him for murder that night.
Correct.
So is it your testimony that you and the detectives went back in a room, rewatched the interrogation video of Mr. Rodriguez, reviewed all the evidence, and then you came back into the room as we see on the video and then charged him with murder and put handcuffs on him?
No.
Okay, so you made the determination that this was murder that night.
After consulting with other detectives who had watched the video,
Which video are you referring to?
the live stream of the interview as it was occurring.
So there were other officers watching this live stream.
Yes.
And how long did you confer before, how many detectives were involved in that process?
I don't remember.
You don't remember?
No.
Okay,
I know I had a sergeant there. There probably was another sergeant there. At that point, there may have been another detective that was there.
so you don't know who watched this and who you conferred with before you made the decision that it was murder?
You know, it was other police officers and other detectives.
Thank you, sir. In your direct, you also indicated that, you had asked him to come in for an interview, you hadn't made a decision. This was basically just sort of a friendly Q&A, right?
Mm.
Okay, but you Mirandized him as soon as he got there.
Yes.
So legally, it wasn't an interview, it was an interrogation.
It was still an interview, in my opinion,
Well, then what was the purpose of the Mirandize?
because he was not free to leave at that point.
Even though you told him he was?
Yes.
Okay, so it was an interrogation.
Sure,
And the purpose of an interrogation is what?
to elicit a statement,
Elicit, what kind of statement?
a confession.
Right, you have inculpatory information, right? So it's not a friendly Q&A. You had made your mind up that you were going to interrogate him and extract information.
Correct. That was the goal of me talking to him.
Okay, so let's go to your voicemail. Do you remember exactly what you said on that voicemail?
I don't.
Okay, do you
I
recall?
got it recorded, I just don't remember exactly what was
Do
said.
you think it would be helpful for the jury to hear that recording?
Maybe.
Great. Your Honor, may I approach, or let me start with some questions to lead into this. You called him that night and left a voicemail on his phone,
Yes.
and you did that from your office line?
I don't remember how I made that first phone call.
The voicemail that we're talking about you saying it was self-defense, did you do that from your office line?
I don't recall.
One of your work lines?
It was either my work phone or my office line.
And if we were to provide the jury with a copy of that recording, you would not challenge the authenticity of that? Your Honor, at this time, we would like to enter into evidence defense exhibit number 3, the audio recording of the detective's voicemail on Mr. Rodriguez's cell phone that initiated this interrogation.
any objection?
I have not heard this call, Your Honor, may we approach?
Yes.
objection.
All right, defense exhibit number 3 is admitted.
May I publish to the jury, Your Honor?
Yes.
And I'll give the court reporter a copy of the desk, and we have the digital file.
You've labeled it?
Yes, Your Honor. Defense exhibit number 3. I've got it right here. Let me make sure that I don't have.
I would prefer that you play the one that's admitted.
Yes, Your Honor. Thank you. Make sure that
Jamie, may I approach Your Honor?
Yes, you.
Thank you, Judge. Thank you, ma'am.
okay. No, if you'll just switch to the computer, it should be able to do that.
Oh, okay.
And then the HD file. Should be that one. Okay. And I've prevented anything else from being on the screen. I'm just going to play through here, Your Honor.
Hey, this is Detective Chevalier with the Carrollton Police Department. Hey, bud, I need you to call me about the fight that happened over at the apartment complex. There's a good chance that this looks like a self-defense thing, but I can't assume that without talking to you, so I really need you to call me. Don't make this bad on yourself by running from it. We got to talk and get this thing over with, okay? So give me a call. My cell phone number is 972-466, no, that's not it, it's 972-482-5546, or you can call me back on this number that I'm calling you on. This is my desk. You gotta call me, bro. All right, bye.
I'll just unplug from there. So, Detective, in your voicemail, you said there was a good chance it was self-defense.
I did say that.
Now, you've also testified that it was your objective just to get Jerry in.
Judge, I'm just gonna have an objection. I just want to clarify one thing for the record. I heard the detective say there's a good chance this looks like a self-defense thing. I just want to clarify if we can play it again or if there's a transcript. I believe that's what was said.
Would you like to play it again, or are you conceding that?
I think the record will reflect what it says, Your Honor.
I would like, I mean, if
I
it's
can
not
clean
clear.
up my question if you'd like, Your Honor.
Okay, go ahead.
Detective, you said something about it being a good chance of maybe being self-defense. Is that fair? Okay. But your main objective was to get Jerry in. Is that correct? Okay, so was your statement in that recording a false statement or a true statement?
I had no indication or information that this was a self-defense, that there was anything related to self-defense in this case.
So that was a false statement?
Yeah, sure.
Okay, so you lied to Jerry to get him to come in.
I made a false statement, I lied to him, yeah, whatever you want to say.
Okay, in your training and experience, is that something detectives do, is to lie to achieve their objective?
No, no.
Okay, but you lied here to achieve your objective.
I have lied before
Okay.
in interviews.
Are you lying to the jury today?
No, I'm not lying to the jury today.
Okay. And then after you Mirandized him for this interrogation, you told him, I'm not gonna lie to you. You recall that?
If you saying I said that.
Do you recall in the video we just played?
I'm not gonna disagree with you.
Okay. You said, I'm not gonna bullshit you.
I remember saying that, yeah.
Okay. You said, I'm gonna be 100% honest with you.
I probably did say that.
And those were all lies. Even the part about being 100% honest was a lie.
Yeah, maybe, yeah.
Okay, well, let's talk about the maybe. How many times did Jerry ask you if you saw the video?
He asked a couple of times at least.
I counted 8 in that video that we just played. Would you dispute that?
No,
8 times that he asked you if you saw the video of the fight?
correct.
8 times that he indicated that there should be actual footage recorded of the fight and the incident?
I'm not sure if that's my understanding of what he was talking about, but,
Was your impression that he thought the fight had been recorded?
yeah, but I don't know where he was talking.
Was it your impression he was
talking about an Instagram video or another video?
Okay, were you under the impression that he was confused that you hadn't watched like maybe the most critical piece of evidence in this case?
Say that one more time, I'm sorry.
Was it your impression that 8 times that he asked about the video, that he was confused why during this interrogation you hadn't yet viewed potentially the most critical piece of evidence in this entire case?
He seemed to want me to have watched a video.
Why do you think he would want you to watch a video?
I don't know.
Do you think it maybe in his mind showed that he acted in self-defense?
I don't know.
Do you think that would have been a video that would have been helpful for the determination of whether this was murder or not?
I think a video of the actual murder would have been very helpful.
And you said in your response to his 8 inquiries about this video, the first one was, I saw it. Do you remember that?
I
So
was
you
referring-
told him you saw it. Did you tell him you saw the video?
I'm referring to the video that I'd seen at that point from the Instagram post.
You said, I've seen the video in the field. I just haven't seen the whole video yet.
I don't recall if that's what I said. I know that I told him that I had not seen the entire video.
Right. Which video were you referring to when you said you hadn't seen the whole video?
Again, there were 2 videos at that point. We knew there was an Instagram video. We knew there was a partial video from some surveillance camera that was on the building.
I understand. Did you watch both of those videos in their entirety?
I saw the Instagram video and I saw the partial video of the one clip where his car comes up to the other car and stops.
So when he asked you, did you see the video, and you said, I haven't seen the whole video, which video were you talking about?
I was referring to that video. The video where you're talking about I'm talking about the surveillance camera.
What about the one you said when you responded, I didn't watch that part?
Which part?
That's what I'm asking you.
Oh. What was it in response to?
The video of the fight that you indicated that you'd watch, but not in its entirety.
Yes,
Right. You said, you told him you would go back and look at that video.
correct.
But you didn't.
I didn't, what?
You didn't observe any video of the fight.
No, because there was only a portion of that captured on the surveillance camera.
But he was very sure during the entire interrogation that a video of the fight occurred.
I don't know what video he's talking about.
He thought there was a video that would have exonerated him and shown self-defense.
We don't have that video.
We don't. And who was responsible for acquiring all the evidence in this case?
Our evidence text?
What about the lead detective?
Well, I only have a certain number of things I can do at once. We have to delegate those things to be done by other people.
So in your training and experience, you know, the objective was to get him in and to get the statement. Now on direct, you indicated that you hadn't made your mind up yet when you left these voicemails, these calls, and these texts, that it was a murder.
That's correct.
Okay. But you just testified that you'd seen nothing to support a self-defense claim.
Because I haven't talked to him yet.
When you, I guess speaking specifically to this voicemail, when you're thinking of a way to get a suspect in, you need to be creative, right?
Sure.
Okay? You need to be persuasive.
Correct.
You need to be convincing.
Correct.
And the objective was to get Jerry
Was to get him in so I could talk to him.
and Mirandize him and interrogate him.
Sure.
Jerry ultimately did turn himself in.
He came up for an interview, yes.
He stayed in contact with you throughout the night.
He did.
You didn't feel there was a need to send officers out to arrest Jerry.
Not at that point.
You didn't have like a fugitive unit out looking for him.
We didn't know where he was at that point.
Did you have a fugitive unit out looking for him?
No.
Did you have a
Well,
license?
I take it back. We had probably sent some officers up to an address that was related to him, I think in Rowlett, Rockwall. I think it's maybe his mother's home in
Oh.
the city.
But you didn't send a SWAT unit
To.
to go find
No,
Jerry and
no,
arrest him?
We didn't use a SWAT unit for it.
And that's because Jerry wasn't a threat, right?
To who?
To the public that you're in charge of protecting?
Well, I didn't know if he was a threat to the public.
Well, if he's a murder suspect and you're trying to get him in, do you feel that you would let someone who's a known threat just run through Carrollton while you're trying to figure out your case?
That's why I called him, because I wanted to get him in for an interview in front of me, and that worked.
If you had perceived Jerry as armed and dangerous, would you have acted in the same way?
We would maybe have taken a few more steps, but at that point, I made contact with him, he agreed to come in and talk to me, so I let that play out.
And by letting that play out, that included leaving the unmarked officers at his apartment.
Correct.
You pulled the identified squad cars and left all the unmarked cars, or one or two unmarked cars there.
Correct.
And they surveilled him coming home and doing exactly what he told you he did.
That's correct.
Came home, took care of the dogs,
I believe he did, yes.
dropped off his car,
Yes.
and got in the car with his girlfriend to turn himself in.
Correct.
If you thought he was armed and dangerous, would you have let him just go in and out of his apartment and sort of on his own free will come into the police department?
We had people in position to be able to watch him, monitor him. If he had gone a different direction, we would have changed the trajectory of that investigation.
And no threat was observed, so you did not change the trajectory.
We let it play out, yes, just like we planned.
When he turned himself in, he was in the same clothes that he was wearing during the incident.
Correct.
He was voluntary and cooperative.
He was.
There was no indication of intoxication.
Not that I could tell. No.
Okay. No breath test was taken?
No.
No blood test?
No.
No field sobriety test?
No.
No drug test?
No.
There was zero indication of intoxication.
Not that I could tell. No.
Would intoxication have been relevant to your investigation?
I think it would have. I mean, it would have played some part in it for the attorneys at one point.
Well, in your analysis on self-defense or murder, would the intoxication of a suspect be relevant to that determination?
Yes.
What about potential intoxication of a complaining witness?
I'm not sure.
You don't know whether a individual who's lost their life in an altercation, whether their level of intoxication is relevant to your analysis or not?
Sure, it's relevant, but again, that's going to be at a point where the attorneys are going to get involved.
Do we make the determination on who gets arrested for murder?
No.
You do,
Yes.
and you did this night.
Yes.
Did you have the Mr. Mills toxicology report at that time?
No.
Would it have been, do you know what it is?
I have read it.
Would that have been relevant to have at the time?
I think it would have been maybe not relevant. It would have been nice to have had at that very particular moment, but it wouldn't have made my decision any different.
So the results of Mr. Mills' toxicology report would not have impacted your analysis of this case?
No.
During the interview, you did not feel the need to put Mr. Rodriguez in handcuffs?
During the interview?
No?
No.
No restraints?
No.
No added security?
Had plenty of people there. We had plenty of people there.
And what exactly had you reviewed? Let's start with the call and the voicemail that we've heard. At that point, what had you reviewed in your case?
Honestly, I can't tell you what I'd seen up to that point. I know that I'd seen the Instagram video. I think at that point I had seen that partial parking lot video, but I can't say that with 100% certainty. I imagine that I would have already seen that, but again, that could have come while I was communicating with him.
And you had not communicated with the only eyewitness on the case, Brittany Bass?
At that point?
No, you're correct.
What time did I send the voicemail?
It was sometime after 10 and sometime before 2.
Okay. I believe that I would have probably already have gotten the information from Brittany's interview.
But you did not interview her.
No. I interviewed her the next day, I think.
Okay. So you were relying on what another officer had told you from that eyewitness.
Correct.
And
And from the live stream of the video.
now, during your interrogation, you asked Mr. Rodriguez quite a few times about why he didn't drive off or leave. Did anybody ask Brittany why she didn't drive off or leave?
Well, he was parked in front of her.
Is it your opinion, based on watching the surveillance video, that she was not able to leave the scene?
That's my impression of it.
She could not have reversed into the parking spot she was
She
there
could've-
for?
Well, no, she could have reversed. She couldn't have reversed in the parking lot she was aiming for, or parking spot.
Was it the handicap spot?
I don't know. I don't think it was a handicap spot.
But she could have backed up.
I guess she could have reversed.
Okay. And in Texas, if a person is legally in a location, are they required to retreat?
No.
And that we refer to that as stand their ground?
Yes.
Are you aware that in Texas that you're not even allowed to consider whether someone retreats in your analysis?
I wasn't aware that I'm not allowed to do that, but I did do that.
Okay. So you were unaware of the laws of Texas and you did not follow the laws of Texas whenever you decided to arrest Mr. Rodriguez?
Yeah, no, that's not what I said.
Okay. Well, did you know that was the law?
Which law are you asking about again?
In the penal code
Yes,
in our state of Texas,
yes,
it identifies what the duty to retreat is.
yes.
Are you familiar with that?
I'm familiar with it.
Okay,
I couldn't recite it.
Okay, and this is not me talking, this is the penal code, right? It also says that when evaluating that situation, under a duty to retreat, self-defense, whatever, that the fact finder, the person in your situation who's determining whether to charge him with murder or not, should not be allowed, is not allowed to consider whether an individual retreated or not.
Yeah.
Okay, did you know that at the time?
No, probably not. I was familiar with it, but I didn't use that to determine whether I was gonna charge him with murder.
So your line of questioning about why didn't you drive off was not relevant to your ultimate determination?
No, not particularly.
So you don't care whether he drove off or not?
I wish he would have.
Okay, but that was not, as you just stated, part of your legal determination for murder.
I don't believe it was. No.
Okay.
Judge, may we approach for a moment?
Yes.
just picking up where we left off. Whether he left or not, whether he retreated or not, was not part of your determination.
No.
Did you observe Mr. Rodriguez get emotional throughout the interrogation at any point?
I don't recall him getting emotional. Maybe towards the end of the interview, he might have. I don't recall that, no.
Is it fair to say the video will speak for itself?
Yes.
And did you watch the video in the courtroom today?
I did.
Did you see him crying in that video?
Crying?
Yes.
No, I didn't see him crying.
Okay, you missed that part?
I must have.
You said, I want to talk a little bit about the issue with Topgolf and not recovering the knife. What was, so you referred to, I guess it's a law enforcement term, on when you take a suspect to a place to try and find the weapon. What was that called?
Yeah, we call it down and out, field trip, whatever.
And you said it's to try and help the defendant remember where the weapon is.
Yes.
So, is there training on that?
Training on driving a defender around? No.
No, on helping them recall where a weapon would be.
No.
Okay. How many times have you done it down and out?
50, 75, I don't know.
Okay, so it's not uncommon to try to help a defendant or a suspect remember where a weapon might have been.
Correct.
What's the success rate on down and out?
Personally, I don't know my personal success rate on those, but it's pretty high.
Okay, but there are times where people can't recall.
I'm assuming there are, but for me, no. But most of mine I've been pretty successful.
Most or all?
Most.
Okay, so there's been unsuccessful attempts.
Without me knowing exactly which ones you're talking about, I'm gonna say I have a pretty good success rate.
And before you did the down and out, you asked Mr. Rodriguez 5, 6 times where the knife was? Is that fair?
That's fair.
And every time he said, I don't know.
Well, I gradually got to where he was more certain where it was, but
After he was arrested, so wait, let's go through the first 6, all right? You ask him where the knife is, he says, I don't know. Okay. It's your testimony that there's a progression, that the video the jury can watch to determine whether there's a progression or not. Is that fair? Okay. And then after he's arrested, you ask him again, correct?
Yeah.
Jerry has been completely cooperative through this whole process, right?
Correct.
Answer every question that you have.
Yes.
You arrest him for murder and you ask him again something that he's told you 6 times he can't remember, right?
Yes.
And you tell him that if you just cooperate, if you just do this one last thing for us, it's all gonna be okay, right?
I don't remember saying it's all gonna be okay.
Just trying to help you, bro.
Sure. I don't
Okay.
say that.
It'll be better for you.
Maybe.
I'm just trying to put a case together.
I don't know if I said that, I said that, I'm sorry.
And to be fair, I mean, the whole interrogation is under that same sort of ethos, that same mindset of like, you're being creative, you're being persuasive, you're trying to get him to give you the information.
Sure.
And so, all the bro and all the trying to help you, those were all not genuine statements.
I wouldn't say they're not genuine statements, it's just the way I do interrogations and interviews.
Okay. And then he agrees to take you to where he thinks the weapon is. So let's walk through that. He's arrested for murder, correct?
Correct.
He's been fully cooperative on everything, correct?
Correct.
And then he agrees to try to take you where he thinks the weapon might be, correct?
Correct.
Which is called a down and out.
Correct.
Which is law enforcement's way of trying to help a suspect remember where the weapon might be.
True.
situation, why on earth, after all of this, would he he went with you there, right? And he tried to recall where it was.
He brought me to a location, and that's not where the knife was.
The knife wasn't located.
It wasn't located.
Okay. And part of your analysis, part of your interrogation is a determination of credibility when you interview witnesses, suspects. You want to determine their honesty or veracity.
Sure.
You want to determine maybe whether they have a motive.
Sure.
Not required by law, but if one exists. Okay. You want to see if maybe they're hiding something.
Sure.
You want to determine whether there's any inconsistencies in their stories.
Right.
Any inaccuracies in their stories.
Right.
And at the end of the day, you had not interviewed Ms. Bass before making the decision to charge him with murder.
No, I had the information from her review before I decided to make that decision.
But you did not interview her.
I did not personally interview her until the next day.
You did not interview her to determine her credibility.
Not at that point, no.
You did not interview her to determine her honesty or veracity.
No,
You didn't interview her to determine whether she had a motive.
no. To murder Mr. Mills?
No, to provide the testimony that she provided. I don't think was she ever a suspect? That'd be news.
No.
Okay, so you're not implying that Ms. Bass was ever a
I
suspect.
don't understand the question.
Now, so you make the arrest. How quickly did you turn your file into the Dallas County District Attorney's Office to prosecute?
I don't know that.
A day?
A day? No.
2 days?
Again, I don't know. I generally don't get things together that quickly.
Okay, well, if we were appointed to represent him days later, that means you would have had to turn your file in, correct?
I may have sent a partial file in, with maybe no, I don't know. I didn't turn an entire case in that quickly.
Okay, so you turned an incomplete investigation in to the Dallas County District Attorney's Office to proceed forward with the murder prosecution of our client.
No, that's not what I did.
Is that what you just said?
No, that's not what I said. That's what you said. I said I turned in something. If that's what you're saying that I did, I turned in a partial report where I may have been waiting for phone records, for subpoenas to come back, autopsy reports. I include all that once I get it. I'm not sure what you're talking about.
Is a partial report a complete report?
No, partial report is not a complete report.
Okay, thank you. No further questions, Your Honor.
Steve?
Briefly, Your Honor, thank you. Detective Valle, let's talk about this voicemail, defense exhibit number 3. Sounds like to me, you said it looks like, there's a good chance it looks like a self-defense thing. Did you say that it looks like you acted in self-defense?
No,
And again, you did not have the defendant's statement. There was a lot of evidence that was still to come in. Had you made a decision as to whether this was a self-defense case?
no, I did not.
And so as it pertains to the voicemail as well as the video that the defendant kept asking about, you said you lied to the defendant, but are these strategies that are used generally by law enforcement in investigations?
Commonly.
Do you recall how much time had elapsed between when you first tried to contact the defendant and when he called you back, approximately?
It wasn't that long, maybe 30 minutes or so.
Okay. And as it pertains to the questions from defense counsel about intoxication on behalf of the defendant, is it your understanding that this offense took place approximately 10:30 p.m.?
Yes,
And you already testified that you interviewed him at about 2:40 p.m.
250.
Okay, so we're talking about 4 hours later?
Correct.
There was also a question about the toxicology of Mr. Mills, and you indicated that you didn't have that information at the time, correct, but you do now?
Yes.
But you also testified that that would not change your opinion, your ultimate conclusion in this case, is that correct?
Correct.
Why not?
I wasn't there. I don't know how he reacts to whatever was in his system. I mean, that wouldn't have made that wouldn't have been a determining factor in me charging Mr. Reed with murder.
Well, you already testified that based upon the statement that the defendant gave you, that you felt like self-defense did not apply in this case, correct?
Correct.
And Mr. Mills' toxicology would not have an effect on that portion of your investigation, is that right?
Correct.
You indicated that you were not involved in the first interview of Ms. Bass, that would have been Detective Bonner,
That's right.
but you indicated that you did subsequently interview her, is that right? What was the purpose of that?
Just to short her story to make sure that it was consistent.
And was it in fact consistent?
It was.
And did your interview, the second interview of Ms. Bass, did that change your conclusion on this case at all?
No, it didn't.
As it pertains to trying to find the knife, you testified that gradually over the course of the interview, Mr. Rodriguez became more and more sure that he could help you guys locate the knife. Do you recall him telling you that he was about 90% that he could help y'all locate
He
the
did
knife?
say that.
So you testified that you did not consider the fact that Mr. Rodriguez did not leave prior to this altercation, but you asked him about different options that he had, correct?
That's correct.
The option to get in his vehicle and basically avoid the confrontation.
Right.
Are you trying to understand the mindset of the defendant with those questions?
Yes.
Thank you. I'll pass the witness.
Defense?
Yes, Your Honor, thank you. So how an individual responds to a foreign substance, narcotic, alcohol in their body is not relevant to your determination of how an incident occurred.
How they respond to it?
Yeah, and if you'd like, I can clean that up a little
Yeah,
bit.
it would.
Great, on the redirect, you were asked about the toxicology report,
Sure.
and you said that it wasn't relevant.
It wasn't relevant to what I was doing.
And you said it wasn't relevant because you weren't there to determine how he responds to different drugs or alcohol.
Yes.
Okay, so is it your testimony that how a person responds to intoxication as lead detective on a murder case is not relevant to your analysis?
I'm not saying it's not relevant. I'm saying it could play a factor.
So if you just said it wasn't relevant on redirect, now you're saying it may be or is relevant.
I didn't use that as a determining factor to charge him with murder.
Okay. You didn't have that information at the time when you charged him with murder.
No.
So how could it be a determining factor?
It wasn't. I didn't have it.
Would it have been relevant?
I suppose it wouldn't.
Okay. No further questions, Your Honor.
Anything else, Ms. Witness?
Nothing further, Your Honor.
May this witness be released?
No objection.
No objection, Your Honor.
Thank you, you're free to leave. Ladies and gentlemen, let's take a 15-minute break at this time, and be back at 11:25.
All rise. Elizabeth Ventura. Before she comes in, Judge, the state would offer State's Exhibit number 136. These are records from the Carrollton Fire Rescue Department with regard to treatment that was provided to the defendant, Gerardo Rodriguez, as well as State's Exhibit number 137. These are hospital records from the Carrollton Regional Medical Center. It pertains to treatment that was provided to Gerardo Rodriguez, as well as State's Exhibit number 138. These are Carrollton Fire Rescue patient records pertaining to complainant Michael Mills. And finally, State's Exhibit number 139. These are hospital records from Texas Health Plano with regard to treatment that was provided to the complainant Michael Mills. All these are accompanied by a business records affidavit. They've been filed with the court at least 14 days prior to trial, and have also been tendered previously to defense and discovery.
Your Honor, at this time, I'm going to object to hearsay, and also if I may have to take this expert on voir dire to see if she relied on these records.
This is not pertaining to Dr. Ventura.
Yeah, this is not regarding the next witness. This is, these are accompanied by affidavits, business records affidavits that, the G-men have been on file for the, statutory number of days.
Yes, Your Honor.
Right?
So who would be presenting this information to the jury from the witness stand and going through this information?
I was just asked to summarize the records because they would be admitted into evidence.
To summarize, you're going to be asking the medical examiner to summarize?
No.
Okay.
I'm offering them into evidence. If the judge lets them into evidence, they will be in evidence, and I was just asked to summarize them.
We have no.
May I, Your Honor?
She's
Started.
approving the objection.
Yes,
One
okay.
person.
In regards to the summary that's going to be presented, we'd like to know exactly what that summary is going to be. And also, it also still needs, there's still hearsay within hearsay in those documents. And so I'd like to know what the summary would
Would you like to look
be.
at the documents? They've been on file.
No, I
So
understand
look
that.
at the documents and tell me what portion you believe is hearsay and et cetera.
And just in response to the summary, Judge, I would basically read directly from the documents.
So, Your Honor, at this time, I understand the business records affidavit does purport what these documents are,
Right?
yet the information contained within here would not allow for us to confront any of the individuals that generated these reports and provided these statements within these documents. And so, due to confrontation, we still need to be able to cross-examine any of these witnesses regarding the hearsay statements they put in these reports. There's a Jessica Nelson that authored reports. There's various individuals listed in all of these documents that had portions generated. And it would be a violation of the confrontation clause for us not to have those individuals on the stand for cross-examination.
Thank you. What's the state's response?
Judge, with regard to hearsay, hearsay is allowed for the purpose of medical treatment. Again, these records have been properly filed with the court under Rule 9010. And again, these are records that are routinely admitted into evidence in these types of cases. And so, again, we would ask that they be admitted into evidence.
And I'll ask the defense, what exactly is contained in those documents that's objectionable hearsay?
I would have to,
Otherwise, yeah, if you want time to look at it.
can we have time to review them and highlight?
So,
All right, in the meantime, go ahead. with
Yes.
your next witness.
Dr. Ventura, how are you?
Good, good morning.
If you could please introduce yourself to the jury by stating your name and spelling it for the court reporter.
My name is Dr. Elizabeth Ventura, ELIZAVETHVENTURA.
And Dr. Ventura, how are you currently employed?
I am the Chief Medical Examiner for Collin County.
And how long have you been the chief medical examiner in Collin County?
I started last November 2024 at Collin County as their Chief Medical Examiner.
And where did you work prior to the Collin County Medical Examiner's office?
Before that, I was at SWIFS, which is the Southwestern Institute of Forensic Sciences here in Dallas. I was a medical examiner for approximately 12 years prior to taking the Chief Medical Examiner position in Collin County.
Just generally speaking, what does a medical examiner do?
So a medical examiner performs autopsies in order to determine the cause and manner of death for an individual when they die.
And what is an autopsy?
So an autopsy is done.
I'm sorry to interrupt, the juror has a question.
Who has a question?
So Dr. Ventura, you were describing what an autopsy is.
Yes, so when a person dies and their death falls under the jurisdiction of a medical examiner, their body is brought to the morgue and an autopsy is performed, an external examination and an internal examination. So the body is brought in, a medical examiner examines the external portion of the body, documenting any physical characteristics, any signs of natural disease, any signs of trauma to the body. And then an internal examination is done to further document those injuries that are on the external to see if they continue internally, as well as document any internal disease processes. And an autopsy report is completed at the end of the autopsy. Specimens may be collected, x-rays may be taken, additional specimens may be collected for analysis, and all of these are done in order to determine the cause and manner of death for an individual.
Okay, let me direct you to an autopsy regarding the complainant in this case, Mr. Michael Mills. Did you conduct the autopsy in this case?
I did not perform the autopsy in this case.
Okay, who performed the autopsy in this case?
This was performed by Stephanie Burton.
And was Dr. Stephanie Burton employed by the Collin County Medical Examiner's Office at the time of this autopsy on August 31st, 2023?
Yes, she was.
Is she employed with the Collin County Medical Examiner's office now?
No, she is not.
Okay. Have you had to testify in other cases with regards to Dr. Burton's autopsy?
Yes, I have.
Okay. Were you able to review the autopsy report and other records, photographs, bench notes, things of that nature in this particular case as it pertains to Dr. Burton's autopsy of Michael Mills?
Yes, I was.
Okay. If you could just talk to the jury about, just kind of walk them through the autopsy in this case, starting from receiving the body.
So after reviewing the autopsy, the photographs, and the investigative report, the autopsy report begins with the external examination. In the first paragraph, it's documenting how the body was received. The body was received in a hospital gown, and any other clothing or personal items that were received with the body are documented. Followed by another paragraph describing the physical characteristics. The weight, which is 180 pounds, and height, which was documented at 72 inches long. Additional characteristics are described, such as hair color, build of the body, any description as well, including eye color, the natural teeth are in fair condition. These things are documented under the external examination. There's an area describing the marks and scars on the body. The body had multiple tattoos, and those are described in the locations that they were found. The body also had evidence of treatment. There's a paragraph that describes the treatment that was on the body when it arrived at the morgue. And then there's an area describing the evidence of injury, which included a stab wound of the chest. So this portion of the autopsy documents the injury that was seen on the external part of the body and also on the internal part of the body. So in this area, documentation of a stab wound on the left anterior chest is documented, and it measures 1 inch by 3/4 inches on top of the body. When it's reapproximated, which means when the edges are repositioned to their more appropriate position on how the knife went into the body, it is reapproximated at 1 inch and 3/8 inches. As the stab wound perforated the body, it went through the anterior chest musculature. It perforated the anterior left fourth intercostal muscles. It fractured the anterior left fifth and sixth ribs. It perforated the pericardium, which is the sac that surrounds the heart. It went through the anterior lateral wall of the right ventricle of the heart, and it perforated the posterior right ventricular wall of the heart, going through the intraventricular septum. And associated with this stab wound, there was about 20 milliliters of blood in the right chest cavity and 2,900 milliliters of blood in the left throat cavity, which is almost 3 liters of blood in the left chest region. And a maximum depth of penetration of 6 inches was documented, which meant the injuries as they went through the body totaled about 6 inches in length. Evidence was also collected during the autopsy, and there's an area documenting how fingerprints, palm prints, the handbags, the hair standard, a blood standard, fingernail scrapings, fingernail swabs, clothing, a hairband, jewelry, a chest bandage, a hospital blanket, and hospital towel were collected and submitted as evidence. The last portion of the autopsy report documents the internal examination, and this portion is mainly documenting any natural disease processes noticed during the autopsy report. And reviewing that, there was no documentation of any significant natural disease. Mr. Mills appeared to be a healthy 25-year-old male. Also during the autopsy, specimens for toxicology were collected. Femoral blood was collected, and it was positive for metabolites of marijuana. All other drugs and alcohol were negative. They also collected fluid from the eyes, and that was analyzed to give the electrolyte analysis, and those numbers were within normal numbers. And the conclusion was that Michael Mills, and I concluded after reading the autopsy report that Michael Mills died of a stab wound of the chest, manner of death, homicide.
Okay, so with regard to the evidence of injury, going back to that section, the stab wound of the chest, talked about the actual damage that the knife did. You said that the wound track was about 6 inches deep, is that correct?
Yes.
And with regard to the damage to the actual heart, would you describe that as a severe injury?
Yes, a fatal injury.
The damage to the heart, is that something that somebody would be able to survive,
No.
even if they were given immediate medical treatment or attention?
No, the fact that it went through the front of the heart, back of the heart, and perforated the intraventricular septum, which separates the heart into the right and left sides, this injury was not survivable.
You also talked about the toxicology in this case, that there was marijuana in the complainant system.
Yes.
Are you able to give any time frame on when that marijuana was consumed based on the toxicology results?
No, marijuana is not something that I can testify and say that they were intoxicated with marijuana, because marijuana gets distributed into the fat cells within the body, and when a person dies, those fat cells can leak into the bloodstream and raise the amount of marijuana when it's tested. So as a medical examiner, I can't say whether he was intoxicated at the time of his death or whether he, within a month, had used marijuana.
Okay, and again, with regard to the effects of marijuana, can you testify as to how this would have affected, and you kind of alluded to this, how this would have affected Mr. Mills's behavior at the time of his death?
If he was intoxicated?
No, not whether or not he was intoxicated, but any effects that marijuana would have had at the time.
No, it would have had no effect on his body in regards to the stab wound.
I guess with regard to his behavior, you said that you couldn't say whether or not he was intoxicated, but can you say whether or not having...
Objection, speculation, and also asked and answered.
Overruled.
You testified that you cannot say whether or not he was intoxicated at the time of his death, correct?
Correct.
Can you testify to what effects any marijuana in his system may have had at the time of his death with regards to his behavior at the time that he died?
So in general, the effects of marijuana tend to...
Objection, speculation, Your Honor. She just explained that she can't discuss whether he's intoxicated or not. I don't see why she can discuss how effects of marijuana can affect Mr. Mills.
Doctor, is this within your field?
This is just in general for most people and how it affects them.
Okay.
I can testify to that.
Okay.
I don't think that's relevant in this situation, because who are most people? And who are the most people that she's spoken to or researched? And has her information been peer reviewed?
I understand what you're saying. Rephrase your question or lay proper foundation.
Okay. I'm not asking you to testify as to how it specifically would have affected Mr. Mills, or, well, let me just ask as a general proposition. You just said that you can speak generally about how marijuana affects people in general.
Yes, from what I've read before in the medical
Objection,
literature.
relevance, Your Honor. We're talking about this particular situation.
Trying to lay the foundation. I mean, when just asked me to lay the foundation, I'm asking those questions.
Okay, lay the foundation.
You referred to, I guess, certain things that you've read or basically on your training experience. Can you
Yes.
tell us about that?
Yes. So according to the medical literature, marijuana acts as an inhibitant. People can have delayed responses when they're intoxicated with marijuana. They may appear sluggish, may appear sedated. Some people get hallucinations or some type of paranoia.
But again, that's in general. You cannot say how any kind of marijuana would have affected Mr. Mills in general or at the time of his death. Is that
Correct.
First witness, Your Honor.
You may.
All right, the attorney, I'm going to show you what's been marked as State Exhibit number 141, as well as 142 through 149. You can review those and tell me whether or not that is the report in this case, as well as photographs that were taken.
Yes, this is the autopsy report and the photographs that I reviewed.
Okay, and as the chief medical examiner in Collin County, are you the custodian of these records?
Yes, I am.
And are autopsy reports and the photographs that accompany them, are they kept by your office in the regular course of business?
Yes.
Is the regular course of business for an employee with knowledge of the events of these autopsies to make records of these autopsies?
Yes.
And were the autopsy report and photographs in this case made at or near the time of the autopsy?
Yes.
And are these duplicates of the autopsy report and the photographs that were done in this case.
Yes.
This time I'm going to do Officer State Exhibits number 141, the autopsy report, and State Exhibits number 142 through 149, photographs tendered to counsel.
No objections, Your Honor.
All right, these exhibits 141 through 149 are admitted for all purposes.
This time may I publish the photographs, Your Honor?
You may.
Can we get the lights briefly, Judge?
Yes.
Thank you. State's Exhibit number 142, Dr. Ventura, what are we looking at?
So this is the unique identification number that is given with the individual when they arrive at the morgue. This number will follow the decedent throughout the entire autopsy process. Any photographs, any specimens collected, any evidence will have this number with it. And in this case, this photograph is documenting a headshot of the individual with that unique identification number.
And for the record, can you just state that unique identification number?
23-3579.
State's number 143, what are we looking at here?
So this is our as-is picture, which documents how the body was received, with a hospital gown as well as the medical therapy still on the body.
State's Exhibit 144.
So this is a photograph that is documenting the stab wound on the chest prior to cleaning the body. Around the stab wound, which is right above the red number, you can see a lot of blood on the body still.
State's Exhibit number 145.
So this is another photograph of the stab wound after the body has been cleaned. And this is a higher up image where you can see it closer up. And it is right above the red number.
And for the record, that State's Exhibit 146. To the left of the wound, doctor, we see kind of like a, an irregular shape to the left of the main wound.
Yes.
Does that indicate anything to you?
No, so it's contiguous with the stab wound, and it's likely a tear that occurred when the knife was removed from the body.
State's Exhibit number 147.
So this photograph was taken to document the direction of the stab wound. A probe is put into the stab wound, and it shows a little bit of that angle of how the knife entered the body.
And I believe you testified that the track was back, upward, and left to right. Is that correct?
Yes.
State's Exhibit number 148.
So this is that reapproximation. So in the previous photographs, the wound was separated, and that is due to the tightness of the skin. So when the stab wound occurred, the skin pulls away due to the tightness. In this photograph, the wound is being reapproximated. The fingers in the photograph are pinching the edges closer together to give a more appropriate length for the stab wound.
And then finally, State Exhibit number 149. What is that showing?
So this is a picture of the heart, and in the middle of the heart you can see a slit-like defect, which is the traumatic injury in this case of the knife going through the heart.
And again, this is not something that someone would be able to survive.
Correct. The fact that it went through the front, through the back, and through the center of the heart, the injuries were just too devastating.
It may be honest, doctor, but I'll just ask you the question based on the injuries in this case. Would you consider that to be serious bodily injury?
Yes.
I pass the witness, Your Honor.
Thank you, Your Honor. Good morning, doctor. My name is Bahram Muse. It's nice to meet you.
Nice meeting.
I don't think I've met you before, but I'm here to just do some cross-examination, okay? I'm just asking for the truth. We've had some difficulties earlier with some witnesses. I know you're just here to testify about your medical exam, correct?
Correct.
Or what you reviewed.
Yes.
Somebody else did. So let's start with, can you explain to me why Dr. Burton no longer is employed with your office anymore? Do you know why?
No, she resigned before I actually became the chief medical examiner.
Do you know when she resigned?
I think October of 2024.
Okay. And no information about what the reasoning for that resignation was?
Not to my knowledge.
So we don't know if it was forced or chosen?
She resigned,
Okay,
and that was all I knew.
thank you. When we talk about the height of the decedent, you said 72 inches tall. Is that 6 feet?
Yes, it is.
And the weight for Mr. Mills was 180 pounds?
Correct.
And could we agree with the photographs that we reviewed that he's a fit gentleman?
Yes, he's well-developed, well-nourished.
And muscular, not
Yes.
overweight?
Correct.
And when you talked about the wounds, we only discussed one stab wound, is that right?
Correct.
The stab wound that you analyzed the photographs of, did it seem like a slashing type wound or more of a puncture wound?
It was not an incised wound, which typically is longer in length on the skin. It
An
was a stab wound.
So, and can you explain to all of us what incised wound is?
So incised wounds are typically superficial wounds to the surface of the skin, and they tend to be longer on the surface than deeper internally. Stab wounds tend to go deep into the body, and then on the surface, they're shorter. So maybe like, in this case, an inch on the surface of the skin, but 6 inches deep. That's a stab wound.
In your experience as a medical examiner and reviewing cases just generally, stab wounds can also be caused for reasons, well, let me ask you this. You're not here to determine what the reasoning was for the loss of life, is that correct?
Correct.
You're determining what was the cause of life for it to be lost.
Correct.
When it comes to discussions about self-defense, you're not here to talk about that, correct?
Correct.
And that's not something that you were able to determine via an autopsy.
Correct.
When we're dealing with situations of protection, maybe protection of oneself, others, or their home or vehicle or property, is it common to see one single stab wound or one single gunshot in situations where a person's protecting themselves?
Objection, speculation, relevant.
Sustained.
When you receive cases as a medical examiner, there is some information that comes through from the medical examiner investigator, is that right?
Yes.
And who gives that medical examiner investigator information?
They typically will collect whatever information they can, either from law enforcement, from witnesses at the scene, or from family members.
And in this particular situation for Mr. Mills, do you know what was done and how that information was obtained?
From what I recall, the death investigator would have spoken to law enforcement and tried to obtain any information regarding the circumstances of how the injury was occurred and any other circumstances as to what led up to the injury.
So in this particular case, you don't really know for sure, right? Because you haven't spoken to the death investigator about it. Is that right?
I did not speak to anybody, I just reviewed the investigator report.
Okay. And, but based on general understanding, the death investigator would have gotten the information from law enforcement, in this particular situation, Carrollton Police.
Yes.
And when we talk about, have you ever received a medical exam that provided information about self-defense from the death investigator?
No,
You never get those types of
we're not,
cases.
they're really not supposed to ask questions about self-defense, they're just trying to find out what happened and the circumstances surrounding it.
Why is it that they don't ask about those things?
I don't know if they do ask, but they don't put it in the report, because it's something that I don't need in order to do the autopsy.
And you as the head, now the head medical examiner, would you agree that that's for the jury to decide what's self-defense and what's not? Is that correct?
I'm sorry, can you rephrase that?
As a medical examiner, that's not important to you. You explained that that's not important for you to understand how the death was caused, correct?
Correct.
Would you agree that any choices about whether self-defense was a valid claim or not comes from the jury? They decide that information.
All I can say is that it's not my decision to determine that, and that's it.
Let's talk about the toxicology. You gave a general testimony about what you know about marijuana to do to people, and you said that it can make some people kind of slower in their judgment.
Yes,
And then you also said that it could cause some people to be paranoid.
yes,
And then, can we agree that marijuana can also cause some individuals to have some emotional imbalances, perhaps?
what type of emotional imbalances?
Getting mad when it's not that necessary to get mad, or getting sad when it's that necessary to get sad. Emotions become very heightened for some individuals when they're using emotional and mind-altering drugs, correct?
There might be some type of mood disturbance, but I'm not familiar with specific ones that specifically occur with marijuana.
Okay, but earlier you said that you did, and you read some articles.
Yeah, so I didn't read anything about a mood disturbance, is what I'm saying.
So what articles did you read to give your prior testimony to this state when they asked you the question?
Just general knowledge about drugs in general, over my years of practice. The typical things that marijuana does cause is typically inhibited responses. It's more of a relaxant, and people tend to be hungry. Their, blood tends to dilate, which is why you see the redness in the eyes. Some people have been documented as having hallucinations. Some people may get paranoia. But specifically mood disturbances, I don't recall in the literature any specific instances in that regard.
Okay. Should people be taking marijuana if they're under medications for mental health stuff?
People in general should not be taking marijuana at all,
Why do you say that?
because it's an illegal drug.
Is it important to, let's talk about have you reviewed the studies about young men in psychosis with heavy marijuana use as a young adult?
Have I read that specific article?
Have you heard about that in your field?
No.
You've never heard of, especially young men who use, or women even, that use drugs like marijuana or any other psilocybin mushrooms, anything like that, prior to the age of 25, that could really harm their emotional development and mental development. Is that correct?
Judge, at this point, I'm going to object to relevance. She already testified that she's not familiar with this.
Sustained.
So you're just familiar with general idea that marijuana makes people tired and hungry, and some people paranoid.
So, in my knowledge, I know the basics of most illicit drugs, like cocaine. I know it's a stimulant. Fentanyl, it's more of a depressant effect. I know the general effects of what the drugs do on the body. I don't know any detailed specifics. That's beyond my expertise. That's more of a toxicologist. who can give you those detailed, descriptions of the drugs in general.
Do y'all have toxicologists at your office?
No, we send out our toxicology to NMS laboratories.
Do you have the toxicology report with you today that was sent over to them or sent back from them?
No, I do not.
Where is it?
In our records.
Do you recall the amount and levels that were provided in those?
Yes, I have, it is reported in the autopsy report, but the actual documentation sent from NMS is in our records, and only the findings were reported in the autopsy report.
Okay, and tell me what those levels were in your, the autopsy report that you reviewed.
So 11-hydro-delta-9 THC was 2.3 nanograms per milliliter. Delta-9 carboxy THC was 59 nanograms per milliliter. And Delta-9 THC was 39 nanograms per milliliter.
Do you know anything about those numbers? Could you tell me anything based on your knowledge about those numbers?
And so like I said before, marijuana tends to redistribute after a person is dead. So these numbers don't really mean much.
They could actually be higher, correct? At the time of the offense, is that right?
They could be likely, so postmortem redistribution means that when a person dies, the cells that stored the drugs get released into the body. So this may be falsely elevated.
But it could also be falsely lowered as well.
No, so it doesn't seep back into the cells. It leaks from the cells into the blood. So it could be falsely elevated, not falsely decreased.
What did the report from that laboratory say when it came back to? Was it more, you said it's more detailed than just the numbers, right?
So now NMS Laboratories has concluded that they are no longer giving us numbers. They're basically now for marijuana just stating positive or negative. Because as I'm testifying to, these numbers don't mean anything. So now they're basically saying positive or negative.
And also, it's because people don't know how one particular person is gonna respond to a type of drug, correct?
I'm sorry, rephrase that.
A scientist doesn't know how a certain person in particular is going to respond to a drug, correct?
That statement is correct.
You have to have other information through investigation from police or maybe witness interviews to understand what had happened or what their usage was like earlier, correct?
Yes.
When it comes to the report, want to go through one stab wound and there were no defensive wounds. Did you see any, correct, there weren't defensive wounds?
No other injuries were documented
No
or
black
photographed.
eyes to
Correct.
the victim, no scratches or signs of him trying to defend himself from somebody else.
The only injury documented on Mr. Miles was the stab wound.
Pass the witness.
No further questions, John.
May this witness be released?
No objection from the state?
No objections from the defense.
Thank you, Doctor. All right, it's 12:06, ladies and gentlemen, let's take a 1-hour lunch break and be back here at 12:10.
All right. state would reoffer state's exhibits numbers 136, 137, 138, and 139.
Any objections?
No objections, Your Honor.
All right, Stacy, would you, summarize for the record what those exhibits are before we go into it?
Yes, Your Honor. State's exhibit number 136 is going to be records from the Carrollton Fire and Rescue Department regarding treatment provided to Gerardo Rodriguez on September the 1st, 2023. State exhibit number 137 is going to be records from the Carrollton Regional Medical Center for treatment provided to Gerardo Rodriguez on September the 1st, 2023. State exhibit number 138 is going to be records from the Carrollton Fire Rescue Department regarding treatment provided to Michael Mills on August 31st, 2023. And state exhibit number 139 is going to be records from Texas Health Plano Hospital regarding treatment provided to Michael Mills on August 31st, 2023.
Thank you. All right, state exhibits 136, 137, 138, and 139 are admitted for all purposes.
Permission to summarize briefly for the jury, Your Honor?
You may.
So we're looking at state exhibit number 136. Records from the Carrollton Fire Rescue Department, patient Gerardo Rodriguez. Date September 1st, 2023. Chief complaint, cut his hand. The narrative states, patient reported the patient was going to take them to the knife and had allegedly been used in an altercation that ended in a fatality early in the night. Patient was sitting at a table in the interrogation room. Patient was alert and did not appear to be in any distress. Patient reported wounds to his right hand. Patient was cooperative in answering EMS questions appropriately. Patient had what appeared to be dry blood that stays on his shorts. Patient had a laceration to the palm side of his third digit of his right hand at the base of the finger. Patient also had small avulsion in the palm side of the right thumb. Wounds were cleaned and assessed by EMS. Patient's wounds were addressed as charted. CPD was informed, CPD as Carrollton Police Department was informed by EMS of likelihood that patient's wound needed stitches. State exhibit 137. Records from the Carrollton Regional Medical Center. Patient admitted September 1st, 2023 at 6 a.m. Diagnosis, laceration without foreign body of right thumb, without damage to nail, initial encounter. History of present illness, patient presents with lacerations to the right hand and thumb from an altercation overnight. He reports the injury was from a knife. He is unsure of his last tetanus. State exhibit number 138. Again, records from Carrollton Fire Rescue pertaining to patient Michael Mills. Date, August 31st, 2023. Chief complaint, he was stabbed. just a small portion of the narrative. Patient found to be pulseless and not breathing. Fire department began chest compressions. Trauma pad was placed over the top. Occlusive dressing of the wound. To control bleeding, patient was moved to the stretcher and secured with seat belts. With regard to the incident timing details, EMS was on scene on August 31st, 2023, 22:35:52, which would be 10:35 p.m. They were at the patient same date at 10:36 p.m. Transferred the patient to the hospital at 10:54 p.m. and they closed the call at 11:39 p.m. Finally, State Exhibit number 139. Records from Texas Health Plano Emergency Department dated August 31st, 2023. Patient arrived August 31st, 2023 at 10:56 p.m. Chief complaint, stab wound to the chest, found by the police department, agonal breathing, then lost pulse, CPR initiated by the police department. Cardiopulmonary arrest, diagnosis. Cardiac ultrasound patient with no heart motion or volume. Patient has been down for 30 minutes, PEA. Trauma surgeon present, time of death 23:04, which will be 11:04 p.m. Disposition, deceased. Thank you, Your Honor. And at this time, Your Honor, ladies and gentlemen of the jury, the state rests.
Thank you. The defense, the state having rested, what says the defense?
Your Honor, at this time, we'd like to move for a directed verdict. Would you like us to make those arguments outside the presence of the jury or in front of the jury?
I would think so. Outside the presence.
Yes, Your Honor.
All right, ladies and gentlemen, we're going to send you back to the jury room for about 10 minutes. Okay? But please don't go anywhere.
All right.
All right, go ahead, Mr. Pat.
Thank you, Your Honor. At this time, the defense would move for a motion for directed verdict. The defense has presented some evidence to the court and to the jury regarding self-defense. Specifically, the mental state of Gerardo Rodriguez as it came through the testimony of Detective Chevalier and the evidence that was admitted through him, which was our client's recorded statement. Also, his recollection of events about the altercation. There were different witnesses that testified about the aggressive nature of the decedent, Michael Mills. There was no evidence presented to rebut the allegation or the defense's position of self-defense. The Detective Chevalier gave a layperson's opinion that he did not think it was self-defense. However, that opinion was made at the time of the arrest, and within days after that, where him and several detectives had reviewed a video. However, no basis was given by that detective for how he formed that opinion, only that the lay opinion was that it was not self-defense. Ms. Brittany Bass testified that at the critical moment in time, she
Like
was.
you're going into, you know, the whole, your whole closing argument there.
I was concluding with this.
Really,
No, Your Honor, I would,
all the state needs to put on is a scintilla of evidence.
and we don't believe that they put on a scintilla of evidence, Your Honor.
Okay, go ahead.
And I was gonna conclude that Brittany Bass, the only witness the state has presented that could have rebutted the presumption, or that could have proved beyond a reasonable doubt, or rebutted the self-defense claim, did not see the critical moment in time where the altercation occurred. And so we do not believe the state has presented sufficient evidence to proceed forward, and we are moving forward with the directed verdict, or motion for directed verdict, Your Honor.
Thank you. What's the state's response?
The state's position, Your Honor, is obviously we would object to this motion. As the court correctly stated, the state only needs to present some scintilla evidence in this case. We've obviously done more than that. We proved each and every element of the indictment in this case with regards to self-defense. That's going to be an issue for the jury, but the state's position is the evidence in this case shows that self-defense, specifically the use of deadly force in self-defense, was not justified in this case. And again, that should be something that is determined by the jury.
Thank you. All right, well, I'm not the trier of fact, and I'm not basing my ruling on proof beyond a reasonable doubt at this time. That's for the jury to decide. However, the state has brought forward a scintilla of evidence that would require me to hand this over to the jury
Yes, Your
for
Honor.
decision. So your motion is denied.
Thank you, Your Honor.
All right. Let's go to the jury. Please be seated. All right, the record will reflect that the defendant is present, the jury, the state is present, and the jurors are present and seated. So the state of Texas has arrested this case. What says the defense?
Your Honor, at this time, we would like to call Dr. Bedard.
Go ahead. And Doctor, you're still under oath. Defense may proceed.
Thank you, Your Honor. Dr. Bedard, could you please introduce yourself for the jury?
Yes, my name is Dr. Roy Bedard. The spelling of my name is Roybedard.
And before we begin, the court earlier in this process has admitted you as an expert, correct?
Yes,
In what areas have you been admitted as an expert?
in the areas of use of force and self-defense, I believe.
And as we go through this, I want to, for the jury, let's go through a bit of your training and background, and then we'll get into what some of that is, and then how it applies to this case, okay?
Okay.
Could you explain to the jury your current occupation?
I am self-employed. I have a company called RRB Systems International, which is a police and corrections training corporation, corrections meaning prison systems. I am in the business of developing products, safety equipment, belt systems, batons, holsters, handcuffs, things like that, that professionals in the field use. I am also a curriculum writer. I'm someone who trains law enforcement officers worldwide. I've trained officers on 4 different continents since about 1996. And I also offer consulting work as well. I'm presently in the business of speaking with chiefs and administrations regarding policy-related issues, accreditation-related issues, and of course I do this type of work as well, where I speak to juries about issues relevant to cases involving the declaration of self-defense.
And before we get into some of your professional experience, could you give us a quick breakdown on your educational background?
I have a bachelor's degree in criminology and criminal justice from the Florida State University in Tallahassee, Florida. I have a master's degree in educational psychology and a PhD in that same discipline.
I do want to circle back to the education here in a moment. Before we do that, could you give us a brief explanation or summary of your professional experience?
Yes, well, self-defense is related. I began as a martial artist as a young man, and I later moved into the business of training law enforcement officers. I was a law enforcement officer at the Florida State University Police Department where I started. I then went to the Tallahassee Police Department. Together I worked with about 10 years full-time. And during that time period, as a trainer and an inventor, I developed products that took me out of full-time status as a law enforcement officer, and I began teaching, as I said, worldwide, traveling to different continents and different countries to present training material. Now, during that time, I remained with the Tallahassee Police Department as what we call a reserve officer. This is an officer who is entitled to go work the streets in a solo capacity, enforcing the laws as I did as a full-time officer. I was just essentially used when we were short on shifts, not with a regular schedule. And I remained there until 2015. After 2015, I went to the Tallahassee Community College Police Department, where I became what's known as an administrative reserve. I was being used as counsel by the chief of police as well as the administration of that agency. I am presently with the Walton County Sheriff's Office, which is in the Panhandle of Florida. I am also an administrative reserve officer there. I offer counsel once again to the sheriff and to the administration regarding areas of training, accreditation. Sometimes I do media stuff. If there's an incident that happens, they may call me to speak to the media about some of these otherwise murky areas.
And then throughout your law enforcement career and leading up to today, in addition to that, you've worked with training law enforcement officers and different professionals?
Yes. In addition to doing street work, actual applied law enforcement, I also have been teaching at the police academy. I teach at 2 of them since 1986. My home base, police academy, is just on the outskirts of Tallahassee in a little town called Havana, which serves as our state academy. That's where all of our state agencies operate out of. And I am a use of force and defensive tactics instructor, a firearms instructor, a general instructor, and I have been teaching 3 different areas of law enforcement. One is what's called basic recruit. These are civilians that are coming into law enforcement for the first time, learning about what law enforcement officers do. This is the most basic level of training that we provide. I also present what's called advanced training. This is going to be the area of in-service, where people come back to you, the incumbents, if you will, to learn more about things that they already know, but have to do continuing education. So I present those classes. And then finally, I do specialized instruction. This is essentially train a trainer. So I teach officers how to go back to their agency and teach their officers. So suppose, the highest level of instruction that we have in the state of Florida. So I operate as a subject matter expert for the state.
You've maintained your police certifications and your teaching certifications throughout that, or trainer certifications, I apologize.
Yes.
You still hold your state standards for law enforcement?
Yes.
How many police officers or correction officers do you think you've worked with over the years in this training capacity?
Boy, thousands, especially if you're going outside of the United States, but here within the United States, I don't know, thousands and thousands. I've trained all over the country, and certainly I had groups of 30, 40 at a time over about almost the last 40 years.
And I want to circle back a little bit to your education and something you mentioned earlier in your testimony. How does your education in performance psychology and your experience as a trainer in law enforcement, and then also just your experience as a law enforcement officer, how are those related when it comes to the application of your area of expertise with civilians and law enforcement?
Sure. If you'll indulge me, I'll tell you the story of how I ended up as an educational psychologist. It began as a law enforcement officer, training law enforcement officers, and actually working within the field. And there were some circumstances in which I noted that law enforcement officers don't always do the things we anticipate they're going to do, and they certainly don't always do the things we tell them to do. And rather than jumping to the conclusion that perhaps they were just intentionally disobeying the training directives or disobeying the policy directives, it occurred to me, as it has to other trainers, that something else was going on. So when you look deeper into behavior, what you find out is that the behavior that is put forward by, for example, a policy committee or a legislature in terms of law is usually done in a very calm day with a cup of coffee. But when you're actually fighting somebody, it's not exactly the same. So this issue of stress becomes critically important when you're trying to observe not only behaviors and try to explain them, but how to prevent them through training. So the curriculum development that I was doing as a professional needed this component of understanding anxiety, understanding stress, and how it influenced the training practices that we were giving law enforcement officers. So my thought was, and I worked in the field for more than 20 years before I went back for my master's degree in this area, and I didn't even know where to begin, to be honest with you. I thought at first it would be some type of military studies that I would have to go in to learn about combat in the field from applied sources, people who were actually shot at, people who were actually under the gun, as they say. And it turns out that that's not really where the data is. The data is mostly in sports psychology. It's mostly with people who find themselves in very stressful situations, not the type of stress where they think they won't be going home at the end of the game, but nonetheless very stressful. And issues like choking, we hear a lot when we talk about, the field goal kicker who's got 2 seconds left and he's down by 2 points. And they don't do it right, but they were doing it right the whole game. This type of stress that influences behavior and certainly influences the actions of an individual that are outside what we normally anticipate. So they undertook a study, staying in university about 10 years as a graduate student, learning specifically about what causes behaviors, why those behaviors influence decision-making in particular. That was sort of my area of study, was attention, visualization, decision-making, prediction, those kind of things. And so
Can I ask a question?
Yes, Your Honor. And so, I guess, so touching on what you were just saying, when it applies to your training with law enforcement, the sports psychology part of it provided the most data points that is now being applied to training with law enforcement and civilians looking to become law enforcement. Is that?
It is, and it's because of the context of it. In the sport world, you can actually put somebody in a lab coat, they're observing behavior. You can't do that in front of, say, a police car or on a battlefield, of course. So when we do what's called empirical examinations, where we actually have control groups, we are able to collect data because those situations are controlled. And so the sports psychology world presents the very best, I think, understanding of how anxiety affects behavior. Second to that would be case studies, something you would get from the field, from somebody who's been in, for example, a life and death encounter, and comes back and tells you what that was like. Those aren't quite as reliable, even though they are important, So the sports psychology field is, as you said, where the data is.
And does the source of your data, the source of your studies, the source of your application to these areas, is that generally accepted within the professional community?
It is, yes.
And by that, I mean, what you do is recognized by other professionals in self-defense and use of force.
Yes,
And you teach in other professionals in this area.
I do. I lecture on these issues all the time.
And you've published books, or you've participated in the publishing of books on this issue?
I have, yes.
And I think you may have just said this, but you teach at seminars and different trainings.
All over the world, yes.
And various courts in both state and federal have accepted you as an expert in this area.
That's correct.
Are there, and that would indicate that there are professional standards and requirements in order to present yourself as a self-defense use of force expert?
Yes, I mean, there's a lot of science to it in terms of standards. I mean, it doesn't necessarily have to be a licensing standard as much as the scientific notions of how the brain works under certain given circumstances. These are well accepted principles of my discipline.
And what are some of the different areas specifically that you're familiar with?
With respect to self-defense,
Yes, let's do with like self-defense or decision-making.
so self-defense is kind of an umbrella construct that's built on a lot of different things. When you learn self-defense, I've been teaching self-defense to civilians for many, many years, you teach them certain functional processes. For example, how far to stand from someone, something called a reactionary gap that's based on reactionary timing. How long does it take for your eye to be able to identify a threat, process that threat, initiate a motor action, and do something about it? So that requires some distance. I talk about breathing, the natural gateway to relieving anxiety, something called autogenic breathing. I talk about vision and attention. All of these things are quite relative to the larger understanding of self-defense, and they sort of fit within the realm of psychology of defense. How does the brain work to prepare the body for what appears to be something that is going to become violent in the next moment or two? So I have been qualified to talk about those things and have spoken to the court about those on many occasions.
Are you also familiar with the concept or the theory of relative positioning?
Yes.
What about theory of escalation and de-escalation? I think you
Yes.
touched on that a bit.
Mm-hmm.
Proportionality
Proportionality, yes.
and combat stress.
Yeah, combat stress, I think, is all what I just spoke about, sort of what's going on in the mind during periods of combat when you're fighting.
And as we go through this conversation with, in front of the jury about all of these elements, is it fair to say that these are all very complicated issues that fall under the umbrella of self-defense?
I think so, yes. I don't think they're generally understood. I think the statistics bear out that most people have not been in a situation where their life is in peril, and that's a good thing, by the way. But there is a small percentage of people that have experienced. Sometimes they're professionals, they may be law enforcement officers and soldiers, but they may be citizens as well that have had something happen in their life, in their childhood, sometimes in their adulthood, where they felt like in the next moment or two they wouldn't be alive. But it is a rare number, looking even at the statistical analysis of people that report dangerous violent crimes. It's in the neighborhood of 1 to 3% of the population.
And sort of continuing forward from there, how many times have you been asked to provide expert consultation on these issues?
Over 600 now.
Does that include both law enforcement and civilian?
It does, yes.
Civil and criminal?
Yes,
And have you worked for all sides?
I have.
So you've done work for the state, you've done work for the defense,
I have, yes.
and the civil side, the plaintiff and the defendant.
Yes.
You've testified in Dallas County before.
I have.
Before we get into sort of the application to this case specifically, could you talk talk a bit about, are you familiar with visual perception and object recognition?
I am, yes.
Does that, as we get into this, is that applicable to this situation?
I think it is. It's applicable to every situation. Obviously, when we do threat assessments, it's essentially we're about 70% visual as human beings. It's what we're seeing that's informing what we're going to do next. That's our predictive level of decision-making model, what our eyes are telling us is happening.
And as we get to the application of this case, will you help us understand which one of these applies and where to your analysis?
I hope so.
What evidence have you reviewed in this case?
I reviewed what's called discovery. This is information that came from, in this case, the public defender's office. That was a complete file, if you will, of all of the documents that was presented to the state as well as to the defense, as I believe. I mean, I only know what I saw. But these documents consisted of police reports. They consisted of video, interviews, crime scene photographs, photographs of the defendant's injuries, autopsy report, those types of things. There are others as well, but those come to mind.
I guess let's talk a bit about some of that evidence and your review of it. You saw the video of his interrogation with Detective Chevalier.
I did.
You saw the Instagram video.
I did.
And the surveillance video from the apartment complex.
Yes.
A lot of the different, as you stated, the offense report type documentation.
I did, yes.
When you look at that, let's start with what we know about what Jerry said happened in relation to the surveillance video and the Instagram video. And before we go there, your testimony, I want to be clear with the jury, you are starting from a position that what Jerry said is your starting point of the analysis.
Yes.
And so, to be fair to the jury, we want to explain that, like, we are assuming that what Jerry said to be true when you provide your analysis.
Simply for analysis. I don't assign truthfulness to anyone in the cases. When I do an analysis, I have to assume something is true unless there is some strong evidence to show that it's not, and then I point that out. But otherwise, if I'm unsure of something, then I assume it's true, and that's what I did in the case of the defendant.
And on that note, we've also, I mean, within the evidence you reviewed, you are taking into consideration different statements provided to law enforcement. It's not that you're only considering his opinion or his perception of the situation. It's that we have to have a starting point for the analysis.
Right.
What was your initial thought when you saw I guess let's start with the surveillance video from apartment 628, that from what we have recorded is sort of what we know to be true and undisputed. That in relation to what Jerry and other witnesses say about what happened, is that a good place to start your analysis?
Yes, I think so. It didn't seem to be inconsistent at all with what the defendant said originated this circumstance, that there was a vehicle blocking a few parking spots. I am aware, I've been to the scene as well, that those spots happen to be within eyeshot of his apartment. The surveillance video shows that, it demonstrates that. I've walked to the apartment and looked back on those parking spaces. It would be very easy to tell where the defendant lived had he just gotten out of his car and went into his apartment. So the surveillance video supports all of what his concerns were when he was asked about parking and why he didn't just go into his house and all those kind of things.
And what we know about different witness statements about the lighting and the time of day, what factor did that play into your analysis?
It's hard to say how lighting affects us, especially when you're looking at video, because video is not a true representation of the optics of your eye. Cameras are different, first of all, there's a lot of variability in them, and they generally oftentimes see things better than your eye because they have technology that can brighten scenes up. So it's hard to say what the lighting was, and if you take the lighting of the video that we see, it's only a facsimile of the reality of what probably could be seen. We don't know what the defendant could see on that night, but we do know this, that because we are mostly visual, and visual is fundamentally based on light, whenever you have light sources that are impoverished or are dark, then vision suffers. And so this is where we get into things like object substitution error, where our mind tries to make sense of things that we're not clear about visually. Oftentimes we turn to things like what's known as postural cues. How is somebody holding something that might give me an impression of what might be in their hand? And so we use those kind of cues, all of our senses kind of working together to try to figure out what something is. So lighting matters, but I can't say with any degree of certainty what the defendant saw.
Does this, and I think we'll get into this a little bit more later, but does that begin sort of part of the analysis on signal detection theory on what the eye is able to see and process?
It does, and signal detection theory is really about interpretation of the environment. So in the real world, you have what's known as a veridical truth. This is the objective truth, what's actually happening. And had you had the eyes of God, you would know what's actually happening. The rest of us are going through life with what's called perceptual truth. We're just trying to figure out what's going on, and we're doing that based on a lot of things, not only what we're seeing, but also what's already in our head. Like, for example, something has happened before that's similar to something happening now. The assumption is, well, that's going to happen again. And that happens at the prediction level. So what happens is the signals in the environment are shrouded by what's known as noise. There's a lot of data out there, and there's important data. The important data is what we try to gather from the environment to help us understand what's happening in the now and make a prediction about what's going to happen in the future. But we have to get through all of the noise to get to the important stuff. So signal detection theory is very much related to how well we can see. The things that we're able to see are going to give us more clarity. The things we're not able to see are going to give us more confusion. So with signal detection theory, the idea is that you're trying to gather an understanding of something happening or not happening. It's what's called two forced alternative choices. You know, that car is going to run me over, that car is not going to run me over, that person's going to shoot me, and that person's not going to shoot me. That's kind of the way the brain starts to work these things out under stress.
And would it be appropriate to then transition into the Instagram video? So we have the 628 apartment video that shows sort of the initial, the start of what's happening here. And then we quickly transition into what we see on a visual and auditory piece of evidence. What is your interpretation of the Instagram video?
Yeah, it's just a moment in time, and certainly the event lasted longer than the Instagram video did. There were some interesting features about that. The only part that's captured is where we see the decedent being antagonistic. So does that happen the whole time? I don't know. I don't think any of us know. But the only thing I can say for certain is that the decedent was at some point antagonistic, was goading the defendant out of the car, being threatening, if you will. Let's settle this here, those kind of things. So I'm able to see that. That has been captured. We don't have to speculate as to whether or not the defendant's telling the truth about that.
In your training, or in your experience with training law enforcement, and as it relates to what a civilian and a layperson may feel in that situation, what is the significance of Mr. Rodriguez being in his vehicle while Mr. Mills, who in this snapshot of time on the Instagram video is being the aggressor, how does that relate to what law enforcement is trained and what a response a civilian subconsciously may have in that situation?
Sure. Being inside your vehicle is a tremendous disadvantage when you're stopped. If you were stopped somewhere and somebody walks up on you, you got nowhere to go. You're, as they say, a sitting duck. In law enforcement, I can tell you, we train officers, I've trained them for over 40 years, and this is one standing rule. If you pull a car over, for example, and the driver exits very quickly, you start screaming, get back in the car, get back in the car. If you ever watch police shows, you probably know that, you've seen that. And the reason for that is because police officers feel vulnerable. when they're sitting in their car. If somebody were to suddenly run up, start firing through the windshield, that would be the end of them. They have no ability to mobilize. They can't seek cover. They can't seek any type of support against a sudden assault. So the theory is if somebody's out of their car and threatening you and you're in a car, you should get out.
How does it relate to, if it does at all, sort of the signal detection theory on your visual cues on what you can see this person outside of your vehicle doing or not doing?
Sure. The car also represents some pretty good visual barriers. I mean, you can't see through them, they are opaque. So if you look over your shoulder, you of course have metal and material there that can obstruct your vision. But you also, because of the way that you sit, have a limited range of atlas axis movement in your head on your neck. So you're only capable of seeing a part of the environment. You can't see, for example, 360 degrees like you could if you were out of the car. You could actually turn your body around and see everything that's happening. So you're sort of working with this tunnel vision. Not to confuse it with stress-related tunnel vision, but the tunnel that's formed from the relative position of your head and your neck as you sit in the driver's seat.
Before we move on, you differentiated between like sort of more the scientific concept of tunnel vision and then just the limited view from your surroundings tunnel vision. Is the concept of tunnel vision from the scientific standpoint something that may be applicable at some point in your analysis of this case?
Very much. Scientifically speaking, when you have arousal, and I should probably define that because I think I'll have to mention this several times perhaps during your question. There is something called a Yerkes-Dodson curve. If you can imagine an inverted U, it's this shape, and it's sort of plotted on an XY axis. What we know is that human performance, this is cognitive performance, the way our brains work, and physical performance, the way our bodies work, is plotted against what's known as arousal. So arousal is a sensation that you get when you experience anxiety. A lot of people, when they say, you know, hey, how are you doing? Oh, I'm a little stressed. They may not have thought about what that word means. Stress has a lot of different meanings. For example, in engineering, you can put a load on something to see when it breaks. That's a stress. Psychologically, we're usually talking about anxiety. Anxiety is a feeling we have when we don't know how something is going to end. When there is a situation in front of us and we're not sure how it's going to resolve. For example, paying your bills. If you don't have any money, you have anxiety. If you have money, you might not be happy about it, but you don't have anxiety. If you ask somebody out on a date, you don't know what their answer is going to be, you get anxiety. So anxiety is about not knowing something. On the arousal curve, a little bit of anxiety actually accelerates performance. So we'll put performance on the y-axis versus the x-axis, which is going to be the arousal. As it starts to increase, performance starts to increase. You think a little bit clearer, you behave a little bit more accurately when you're taking on a task. And at some point, it plateaus. There's only so much elevation on what's called the challenge side of the curve. It's called the challenge side because it turns out that human beings, we like challenges. And when we talk about sports psychology, we talk about this Yerkes-Dodson curve. When two football teams meet, they want to be there. They want to see who's best. They want to examine each other's proficiency on the field and come out a champion. The reason that that's a challenge is because you have certain coping mechanisms you hope that are in place. You hope that your receivers are a little bit faster than the defense. You hope that your quarterback's a little bit more accurate than the other teams. So these circumstances, as you start to become more aroused, start to increase your capacity until you reach that threshold of coping mechanisms. And that's called your individual zone of optimal functioning, and it's unique for all of us. We all have different zones of functioning, and this has to do with something called self-efficacy, right? So two people taking on the same task could approach it very differently. If you're much bigger and stronger than the person next to you and it's a weightlifting task, you'll have a better self-efficacy than the person next to you. If you're older, I hate to say this because I'm getting older every day, you're not going to feel as comfortable taking on tasks that you would have done 20, 25 years ago. So all of this self-efficacy results in where your individual zone of optimal functioning is. Now, when you get that exceeded, when something happens in the environment, you feel like, I can't handle this. My self-efficacy is not adequate to deal with the situation. You start coming down the other side. And what we see is a degradation in cognition your brain's ability to work, and your body's ability to function. And this is the downside of the Yerkes-Dodson curve. This, as it comes down, by the way, does not have to be gradual as it perhaps had coming up. It can be catastrophically a drop-off, and there is a model called the catastrophic model that describes that as well. So under high arousal, depending on how much arousal and your ability to manage the task at hand, your performance will be altered.
And so, if I understand you correctly, a little bit of anxiety can actually increase performance, but once you cross that threshold, there's a dramatic decline in your cognition, your ability to process the information and the situation.
Dramatic. Your brain actually works differently when you cross that threshold. You have what's called system 1 and system 2 thinking, where you go from generally, as we sit here today, a very contemplative, deliberate way of listening to me and, what's he telling me, what do I know about this? You're deliberating on what I'm saying. If something happens very suddenly, your brain will shift into the survival mode, system 1 thinking. And this is where we move into the term is heuristics. Heuristics means these are snap decisions, right? We don't spend time thinking about what am I going to do. We just kind of do it. We just run. We just climb. We just jump. Whatever it is that happens in that moment, we do with very little thought. So it's a highly efficient system because it's not requiring the same cognitive processes that system 2 requires to really brain through something. But at the same time, it is the thing that's keeping you alive. Even if there is error, even if perhaps you've done something that maybe you wouldn't have done had you had time to contemplate, it is that your mind is taking over, it's hijacking the front part of your brain, the prefrontal cortex, shutting it down so that it can't deliberate. It actually changes the way you think.
And so, as we look at the evidence that we have here, we have the surveillance video, we have the Instagram video, where Mr. Rodriguez is sitting in the vehicle, and there's the confrontation. And you also reviewed the 911 call.
I did, yes.
And so you're aware that the 911 call captures the Instagram sort of conversation or argument.
Yes.
And carries beyond past that recording.
I am aware of that, yes.
And when we listen back on that 911 recording, do you feel comfortable identifying one person as the main agitator in that situation?
In parts, yes. I think that I hear the same agitator mostly throughout. I do hear at some point another voice saying, I just want to, almost in an explanatory sort of way, a non-antagonistic sort of way. That's a different voice. Other than that, it's a lot of jumble. I couldn't tell exactly who was saying what. The voice seemed to be consistent from the beginning, and I do know because of the 911 call what that voice sounds like from the Instagram video.
Does and please correct me if I'm wrong here, does the theory of escalation or de-escalation play at all into the sort of progression from we're standing at the car, Instagram video, and then come on, let's go, let's fight?
Yes.
And how would that be the most relevant theory at this point in the analysis, or would there be another theory that you think?
I think that's a pretty relevant theory, and it goes to really models that we use in law enforcement. I only bring up law enforcement not because the defendant is a law enforcement officer, but because it makes sense. If you have a situation that is about to be violent, you're really looking at two different ways of managing it. One is escalating, and that means making things worse, and the other is de-escalating, which is doing your part to kind of make things better. Oftentimes in police work, when we teach escalating, which we have done in the past, we come from a very evolved state of subject control from the 1950s style policing to today's style policing. We emphasize de-escalation today. We do this through verbalization. We do this through cooperation. We do this through psychological processes to avoid use of force. That's the idea. Unfortunately, if you're not a police officer, those rules still apply, but they don't necessarily, people don't necessarily behave in accordance with it because they're not subject to training. So escalation can certainly create a bad situation out of something that's not so bad, and it can make a situation that is bad even worse. So what I hear on that 911 call is a steady state of escalation, a steady coaxing and goading to get out of the car, and why don't you meet me out here, and then there's the pejorative name calling that I can hear some of that as well. This is all escalation tactics. So I think at this stage of the encounter, this influenced sort of my synthesis of this case.
And then moving next to what we know about the altercation, right, the fight, the point of contact. According to the evidence you've seen in Jerry's statement, he gets out and he brandishes a knife. Based on your review of the evidence, what are your thoughts about the decision, one, to equip himself with the knife, and two, I guess let's start with the equipping of the knife and then we'll move into the brandishing of the knife.
Okay, so yeah, there's a lot to unpack with this question, and I'll try to take it one piece at a time. It's my understanding from the defendant's testimony, taking it as truth, not assigning truth, but taking it as being true, that he was goaded out of the car. I think there's some evidence to show that. It's also my understanding that the decedent in this case was significantly bigger than he was, and in self-defense training, we would call this subject factors, right? So when you're making your analysis of whether I want to take on this person, one of the things is he bigger than me? This is why we have weight classes in boxing and wrestling. We don't just let everyone fight everyone else. So this is a moment of, if I have to fight, then my self-efficacy is low. In other words, I don't think I can take on this task based with what God gave with these two hands. What we find is that people will often harm themselves. So people, like all animals, look for some sense of protection. Some animals are equipped with fangs. They're equipped with claws, spikes, venom. We're not. Human beings are equipped with opposable thumbs, and like any other primate. So when we get involved in a situation, it is our instinctual reflexive action to grab something, because that's what we do. If you go back to primitive weaponry, and of course I think this is one of the oldest sciences in the world, you start realizing that humans have always fought with sticks and rocks. But as we've advanced to more certain technology, things that, if you will, do the job perhaps better, we get into things like knives and spears and guns and tanks and now drones and all these different kind of ways of dealing with a situation based on an opposable thumb. So if you have something in your car that is a weapon or can be used as a weapon, whether it's designed that way or not, it is not uncommon for somebody to grab it if they think that their efficacy is low enough that they won't be able to handle the situation. In other words, they won't be on the challenge side of the curve, they'll be on the threat side of the curve, and that's called threat assessment.
And before we move to the next part of it, is it fair to say that equipping yourself with a weapon based on your testimony and training experience is not always an act of aggression, that sometimes it is a defensive tactic?
Yeah, it's interesting, and this is the part to yet unpack, is I think if you don't know some of what we study in ethology, which is the study of animals and certainly self-defense behavior of humans, you may not realize that when for example, somebody rips their shirt off, your first instinct is, oh, he's looking for a fight. That's usually not the case. Usually this is what's called posturing. It's a pre-fight ritual, and we'll talk about animals that perhaps you've seen on TV because they're more common. When a puffer fish is swimming along and a predator comes, they start pulling in all this water, right? So they get bigger. They have the impression, it's a bluff, but the impression that I can take you on because now I'm bigger. And when I say it's a bluff, I mean there's actually nothing behind that threat display. That's known as a threat display. And typically with threat displays with animals, we get bigger, we get louder, we turn colors. Human beings do it as well. We stand up straight, we push our chest out, we start hollering, and we turn red, right? So these features are known as dymatic threat displays because they are not dangerous, they are a bluff. They are intended to just simply scare away the predator by demonstrating that the cost of pursuing this fight is too much for you. You would do better going and messing with somebody else. Now there's another threat display, and this is called an aposematic threat display. And these are the kind of displays that certain animals, like lions, before they engage you, will first show their teeth. They will show their claws. Rattlesnakes will rattle their tails and give you an auditory aposematic signal. They're not doing that because they want to fight. They're doing that because they don't want to fight. They're basically telling you, stay back, or you're going to get the fang or the claw or the venom. Those are attempts to de-escalate. We, as most creatures are, try to preserve energy. We are constantly seeking food. We all know that we have trouble sometimes even with our diets because we're always looking for more energy. So when we have to expend energy, there's always an energy cost. And we are hardwired, the architecture of our mind is hardwired to not expend energy if we don't need to. Fighting is always an expensive energy. So if we can avoid a fight by threatening somebody away, by bluffing them to stay away, that tends to be what we do. So I noted, relating it to this case, that when the defendant says he gets out of the car, he grabs this knife and shows it to him. This is an indicator to somebody like me. When I hear that he's consciously doing a threat display, he's consciously saying to the antagonist, hey, I have a knife here, the cost of pursuing this is too high. This is very, very typical aposematic threat display that we see in all areas of the animal kingdom.
And so you felt that Mr. Rodriguez's threat display was defensive.
Yes.
But on the flip side, how did you apply that analysis to essentially a threat display by Mr. Mills, right? So he isn't ripping his shirt off, but he is saying what we've heard in evidence. He's preparing himself for the fight with the keys and the phone and all of that, and positioning himself. How would you analyze what we know to be true in that situation?
Yeah, so we have two people posturing here, right? And before the fight starts, this pre-fight ritual, they sort of square off for a second. I think in the interview, the defendant talks about that. There is a trail of the decedent getting rid of his keys, getting rid of his cell phone, taking off his shoes. Those are all postural cues. You don't want to mess with me. I'm ready for you, that kind of thing. And so that goes on for a little bit. Unfortunately, that's a dynamic threat. That's not a threat that certainly is formidable against a knife or a gun or some other type of weapon, which is why the defendant in this case, or any defendant or any animal would assume that it would be wholly unreasonable for you to attack once you are shown those claws or those fangs or that knife. So this goes back into signal detection theory, because now suddenly we have a very bright signal of uncertainty. Why is this happening? When I have this knife, I am displaying it. He is aware of it. What's going on? What does he know that I don't know? So this is kind of what I'm seeing as the fight starts to progress.
And so at this point, he's brandished the knife. He's equipped himself with the knife. He's brandished the knife. He is trying to keep distance. He's trying to show, like, please, let's not do this.
Well, that's what he says, so we don't have any of that on video, but he says, I'm standing here with the knife down on my side. I seem to remember him talking about that. And that there is that reactionary gap, right? So reactionary gap is the visual distance. Do you want me to explain what that is in more detail?
Yeah, well, let's get to that in just a second, because on the 911 call, we do hear the decedent, Mr. Mills, recognize the knife.
Yes.
You recall that? And then we also hear Ms. Batts acknowledge the knife on the 911 call.
Yes.
And so at this point, both with the signal detection theory and the other area that you were about to go into, you know, this is a moment-by-moment analysis. We have all the contextual clues to evaluate what happened that night, but at some point, Mr. Mills makes a decision from what we believe to be true, or from Mr. Rodriguez's testimony about what happened, or not testimony, from his recorded statement, that Mr. Mills makes the decision to close that gap, to move forward despite the defensive display, right?
Yes.
And so, if you could, I guess let's start with signal detection theory, and if you have another theory that's applicable, you know, what would a reasonable person in Mr. Rodriguez's position, how would he be interpreting this stimulus, this feedback that he's getting from this other individual?
So I think it's best to explain it theoretically. I don't want to try to get in his head. I don't know what he's interpreting, and that's up for the jury to decide. But I think these models explain pretty well what you can assume he was thinking. So I do want to start with reaction time because it's critical to this moment. So reaction time is the amount of time that it takes for you essentially to perceive a threat and then do something about it. And that takes, on the average, about 250 milliseconds, give or take. 250 milliseconds seems to be very quick, but in a fight, lots of things can happen. You can pull the trigger of a gun, for example, 3 times in a second. That's looking at each shot in about 250 milliseconds or a little bit more. So 250 milliseconds matters. What's happening? When you perceive something in the environment as happening, the first thing you have to do is recognize it. Then you have to analyze it. What does it mean? Then you have to go into the predictive phase of what's called choice selection. What am I going to do about it? Once you have selected what you're going to do about it in your mind, and this is all happening very quick, you then have to do what's called initiate a motor script. And initiating a motor script means that what's happening in the cortex, the thinking, the conscious part of your mind, has to somehow be translated by the muscles. So a signal is sent to the motor cortex, this area of your brain that's up here, that says, and I'll stick with another case just to keep it general. We are being attacked, pull the trigger. So the motor script would be to pull the trigger, make the finger do this. And this becomes automatic, it's automatized behavior. All of that happens very rapidly, but those 4 things will always happen when you're reacting to a threat in the environment. Now let's stick with something you probably more common with, which is driving. When you drive your car, you know that if you get too close to the car in front of you and they hit their brakes suddenly, you'll crash in the back of them. That's what they call tailgating. Why? Because the first thing you have to do is recognize that their taillights came on, analyze what that means. Oh, I gotta put my foot on the brake. Move your foot to the brake and then actually compress it. Those are 4 things that happen. And that's gonna take about 250 milliseconds. So if you're too close or traveling too fast, or heaven forbid both, you're gonna hit them every time, even if you're ready for it. Even if you're saying to yourself, I am going to see those taillights, I know they're gonna come on because we do that when we drive, you're still gonna hit them. So the reaction time principle isn't something you can overcome. It's a gap in our cognition that we have to account for, and we do that by keeping distance. The only way to prevent it is to get farther away. So from an analysis perspective, when somebody violates that reactionary gap, suddenly signal detection theory tells us, oh, there's not anything I can do except that heuristic. I need to run, I need to fight, something called fight-flight. And if you're equipped to fight, that's typically what you do. If you're not equipped to fight, you tend to run. So this process that occurs is something that I have to analyze in every one of the self-defense encounters that I have analyzed in my career, because it's critical to not only what did you do, but what can you do.
And so, at this point, in the sort of play-by-play of what happened that night, is your analysis of the evidence and the recollection that Mr. Rodriguez has, is his response, the duck swing, the closing of the gap, from what we can tell about the location of the keys in the phone and where we think things may have happened, is that consistent with signal detection and with the reactionary gap?
Yes.
And to touch a little bit more on signal detection, and also in your experience in law enforcement, how on earth is a person in Mr. Rodriguez's position supposed to know, perhaps connecting to the anxiety and arousal theory, to know what the threat is in its entirety, that he's not going to pull a gun, that he's not going to pull a knife, that he's not going to disarm him and then take his knife and then use it against him. Could you, if appropriate, elaborate for the jury on that concept?
Sure. The simple answer is he doesn't know, and this is why signal detection theory relates to it, because signal detection theory is what we do in the absence of full evidence, when we have a period of uncertainty. It comes out of World War II, or just after World War II, this theory where we were trying to, as a decision-making model, figure out what to do with radar. What is that blip on the radar as it circles through? I think if you've ever seen an old radar, there's a blip there, there's something there. Is it enemy aircraft? Is it friendly aircraft? Is it a flock of seagulls? We don't know. We have to figure that out. So what do? Is we start to analyze things about that dot. What's its velocity? How high is it? What's its altitude? Is it heading towards me? Is it heading away from me? So these are all signals. You're trying to get rid of the noise of the other things it could be. and trying to zero in on what it actually is. And you're doing this in the absence of certainty. So in a self-defense case, it's essentially taking that same model that has been applied to psychophysics. Doctors and surgeons use the signal detection theory when they do their diagnosis. Lots of people use this theory to figure out what should I do given this set of circumstances when there's only limited information available to me. So the signal detections in this particular case is you have, I think we covered some of those, antagonistic behavior, a coaxing into the field, you have a reactionary gap, and steady verbalization of threat, and then you have a violation of that reactionary gap. At that moment, there's two things in signal detection theory that matter. In signal detection theory, I mentioned to you earlier, has what's called two forced alternative choices. When it gets down to the sudden decision, you don't have time to think there might be 10 things that could happen. You think there's two things. That car is going to run me over, or it's not going to run me over. That person is going to punch me, or they're not going to punch me. That person is going to stab me, or they're not going to stab me. That's two forced alternative choices. And what happens is you bias yourself towards the strongest signals. So if the signals are, you're going to punch me, then you lean towards, I'm going to react to what I anticipate is going to be a punch. If the signals are, you're not going to punch me, then I'm going to be a little bit more conservative and not make my decisions so soon. But the two things that matter are consequence. What happens if you punch me? And the second thing is time pressure. How much time do I have to decide what to do about it, right? So when that dot is on that radar screen, at some point it gets close enough. You have to shoot it, even if you don't know what it is. And we did that in 1980, and we shot down an Iranian jet, killed about 200 people. And the military put a lot of money into studying this program called TADNIS, Tactical Decision Making Under Stress. And the purpose of it was for exactly situations like this. What do we do when we are under high consequence and high time pressure? What do we do when we don't know what to do? So that's very relative to this case.
And so based on signal detection theory and the gap in the mind's natural ability to process the information, in that moment, you know, these are all things that a mind is trying to interpret when a threat advances upon you, despite all of the context, clues, or facts, or evidence. Is that fair to say?
Yes. Object to leading, Your Honor.
Sustained. I think he's covered this area. Please move on to the next.
You mentioned punching. We know that Mr. Rodriguez displayed the knife. In your experience, can hands or feet during a physical altercation also be deadly weapons?
The answer is yes, most definitely. Whether it's direct, in other words, you get punched or kicked in the head, for example, and die, that has happened, but also secondary injuries. The problem of getting punched in the face, falling down, hitting your head on the ground, and suffering perhaps a subdural hematoma that kills you when you sleep. Those kind of things happen, and they're not infrequent. They happen quite often. So, you know, if there's a problem with law, it's this idea that you believe your life is in imminent danger. You only know that after you're hit. The presumption of imminent danger should be just about any attack, because you just don't know if you are going to fall, hit your head on the concrete in the next moment, or if the punch itself will cause you great bodily harm. Perhaps it doesn't kill you, but you're different from then on out for the rest of your life. Those are things that you have to take into consideration when you decide to use a defense.
And so, before we move on to a different part of his interrogation, well, I guess first let me ask you, based on the totality of what evidence we have that we believe to be associated with Mr. Mills, do you think a threat was present and being displayed towards Mr. Rodriguez?
Yes.
Do you believe that his response was reasonable?
I believe his response was reasonable, yes.
Just for clarification, Your Honor, would say his, who are we referring to?
Do you believe Mr. Rodriguez's response to the threat from Mr. Mills was reasonable?
I do.
Now, we have the video evidence, right, and we have his interrogation. I want to speak briefly about, I believe it's a concept of like fragmented memory, is that correct? When he was being interrogated, and he said that Mr. Mills got out of the driver's side, or that Ms. Bass got out of the passenger side, can you explain the trauma response and the interaction in the mind on why he may have misremembered or misperceived that in that moment?
Yeah, so with acute stress, oftentimes what happens, there's a signal. You have this thing in your brain called the amygdala. It's a little neural cluster. It's on constant vigilance against danger in the environment. And the amygdala is very good at telling you, don't step out on the curb. I hear an approaching vehicle. Your head turns, you see a vehicle, you stay on the curb. It's your amygdala that's doing that. It's trying to keep you safe all the time. If there is a pronounced threat in the environment, not a common threat like a car coming, but perhaps somebody coming at you is threatening you, the amygdala goes on, it becomes hypervigilant. It becomes very concerned about that particular threat. And what it does is it actually creates a chemical change in your body. And this is one of the interesting things that I had to learn about when I went back to school, because I saw it in the field but didn't understand the process. It initiates something called a SAM axis. Okay? This is a sympathetic adrenal medullary reaction. And that activates something called an HPA axis, the hypothalamic, the hypothalamus of your brain, the pituitary gland, and then the adrenal glands. All of those things start to get engaged because the amygdala is telling them, hey, we got trouble coming. And what they do, first of all, there's a part of your brain in the back that is called your reticular formation that has a little thing in it called the locus ceruleus. And what it does is it excretes norepinephrine. Norepinephrine is a chemical that starts to change you. If you've ever heard of an adrenaline dump, this is sort of the beginning of an adrenaline dump. When norepinephrine gets in your brain, it does some pretty extraordinary things. It turns on the SAM axis, it turns on the HPA axis, but it has a profoundly bad effect on memory. The theory of that is that what's the point of encoding and imprinting memories if you're going to be dead in the next 10 seconds? So memory sort of gets fragmented. It's information's coming into your head, but it's not being laid down in the cortex, this wrinkled part of your brain. When you look at a brain and you see that, that's where your memories reside, in some area of that. It sort of holds them in residence. And this is all because of the activation of the sympathetic nervous system. So this chemical response, especially the HPA axis, the hypothalamus secretes hormones to the pituitary gland. It tells it secrete hormones into the bloodstream. It releases bloodstream hormones called catecholamines that flow down through your system, and then your adrenaline that come from your adrenal glands that sit on top of your kidneys just dump into your system. So if you've heard the term adrenaline dump, that's what that means. That's cortisol, epinephrine, norepinephrine surging through your body, mobilizing you for survival. Here's what happens. You become faster, you become stronger, you become more endurant for a short period of time, but you also lose track of memory. So memory gets fragmented. It's not really capable of being quickly recalled. You have another part of your brain called the hippocampus, and this explains that process. The hippocampus is like the dispatcher, if you will, of all of the sensory information coming in. It gathers something, it encodes it, and it sticks it in some part of your cortex. And we can actually see that. We have technology. We can put a fMRI cap on your head and ask you questions about, what did you have for lunch? And you can say, oh, I had tuna fish. And there'll be a spot on your brain that lights up. That's what that memory is. So when it comes down to these memories, they're not on the cortex. They're not there yet. What we seem to think is that it requires restfulness and in particular sleep cycles for them to do what's called consolidate. These fragmented memories come together so that they're able to be placed in the cortex and recalled. Now, please know this.
Well, before you get into that,
Okay,
let's hit pause right there.
Okay.
I do want to get to that point in just a moment. But just so that I understand, the science does support that after a traumatic experience, you can have this fragmented memory.
Oh, absolutely.
And memory distortion.
Memory distortion, yes.
And so that's not an indication of dishonesty. It's someone potentially trying very, very hard to tell the truth, but their memory has been affected by the traumatic event.
Right.
To lead in, Your Honor, once again.
Sustained.
So So there's a difference between memory distortion and memory loss. Memory loss is you don't have memory, it's just not there. And the danger of taking interviews too early is that you can create memories that aren't there. These are called false memories. Perhaps you've heard of them before. If somebody, for example, an investigator says, well, this must have happened, and you have a memory loss, you're going to think about that happening and go, yeah, I guess that must have happened, and that will become your memory. So this memory loss is not a distortion, it's a creation, it's a fabrication of information that's not actually there. And police know this. We don't interview ourselves if we're involved in officer-involved shootings for 24 to 72 hours after the fact, because we want the officer to go through a proper sleep cycle, so when we ask questions, we get good information. Otherwise, what we see, by the way, it's a terrible double standard that we're doing this with citizens. They don't get that 24 hours. They get questioned immediately after they're brought in. Those memories oftentimes aren't fully formed, and as a consequence, what happens is you get information out that's not accurate, certainly if it's on video where you have other people there that have witnessed it as well that are telling a different story. And then, of course, the question is, well, are you lying then, or are you lying now as you sit here before us? And the truth is, you're not lying either time. That's the recollection that they had the first time, and this is the recollection they had after consolidation. They're just turned out to be different stories. Now, memory distortion, I'll address that. That was memory loss. Memory distortion can occur because I talked about things like postural cues, like what is it that makes me think you're holding a gun? Well, it's the direction of your arm, where you're reaching. We also have other types of cues. Like, for example, one of the things that I noted in this particular case, this disturbance in memory about who was driving, who was the passenger, what I do remember is that when the decedent came out, he started saying, all this stuff you've been saying to me, boy, he was doing that to me, to me, to me. I'm reasonably sure that either the defendant never saw him get out of the car, probably looked up and there he was, or if he saw him, had no memory of him coming out of the car. But did recall the threat, and the threat was, why are you saying this to me? Here's what I saw in the video. When the defendant walked up to the car, he walked to the driver's side. He was speaking to the driver, not to the passenger. He was speaking to the driver. So the suggestion that was given to him in this fragile period of memory consolidation is, if you're speaking to me, I must have been the driver. And that's what I anticipated probably happened. Otherwise, I can't explain it. I don't see how it benefits his case to decide who's driving and who's the passenger. So I didn't see any self-serving purpose for doing that. It just seemed like it was a typical construct of either distorted memory or lost memory, one of those two things.
And distorted memory, memory loss is something that you have seen with law enforcement and civilians in your training experience?
Almost every case, yes.
I guess sort of in conclusion, you watched the interview of Mr. Rodriguez in its entirety with law enforcement?
I did.
There was nothing in his explanation of events that made you feel like his response that night was unreasonable?
No, I think what he said comported with the other evidence that I was looking at.
Based on your training experience, you felt that his story was credible and consistent with what you have experienced in this field of expertise?
Yes.
And that that Mr. Rodriguez acted in self-defense?
I think it's up to the jury to decide that.
Fair.
But I would say if this was a policy-related matter where you brought this case to me and said, hey, this is one of your police officers that got involved and all the facts were the same, I would say it was self-defense, yes.
Is it fair to say it's consistent with self-defense?
It is consistent with self-defense, yes.
Thank you. No further questions, Your Honor.
Thank you. State?
Mayor Pro Speak, Your Honor.
Yes. Y'all may be seated. We have on the record will reflect that the defendant is present, his attorneys, the state is present, the jurors are present and seated. Is the state ready to cross-examine Dr. Bedard?
Yes, sir.
Go ahead.
Thank you. Good afternoon, Dr. Bedard.
Good afternoon.
We've spoken before in the prior hearing, correct?
Yes, sir.
How much are you being paid for your services in this case?
$3.25 an hour.
And how many times have you testified in criminal cases here in Texas?
I think this is my 5th.
And of the other 4, how many of those cases were jury trials?
Jury?
Yes.
All of them.
Are you sure about that? The last one you testified in was, I believe, a trial before the court. I don't recall the defendant's name, but I'll find that information. And of those cases, how many of those jury trials involved an adult defendant?
All but one.
In criminal cases in any jurisdiction, what percentage of those cases would you say that you testified for the defendant?
In criminal cases, I testify to on a national level.
Yes.
For a criminal defendant, probably 90% of the time.
And so the other 10% would be for the state?
Yes.
Okay. How about here in Texas? Have you testified for the state at all here in Texas?
I have not.
So when the defense initially reached out to you about this case, what did they say that they were looking for?
The defense counsel contacted me and said that they had a case that they believed was a case of self-defense and wanted to know if there were some issues that I might be able to speak to.
Okay, and when they reached out, did they say that they had already formed the opinion that they thought this was a self-defense case, or were they just asking for an opinion in general?
I think when defense attorneys reach out to me, I think they often do already have an opinion. That's why they go looking for me to be able to explain these things. I can't tell you what the defense attorney was thinking in terms of the opinion he formed. My task was to look at essentially a preliminary understanding of the case to find out whether or not it was even something I would talk about. And secondly, when I agreed that yes, this looks like it's in my wheelhouse, to look at the discovery that I spoke about. These would be the items that came in usually through a Dropbox or a share file, something like that.
Did you prepare a report for this case?
I did not.
Did you make any notes in preparation for your testimony in this case?
I did not.
Do you have any experience as being the lead investigator on any homicide cases?
I have been, yes, very few. I was a patrol officer my whole career. I mentioned that I had worked at Florida State University Police Department. This was back in the 80s, and resources were relatively restricted. So I've been a lead investigator in one homicide case. I've been party to dozens of them as I worked as a patrol officer collecting data from the field.
But as the lead investigator on a homicide case, one case, correct?
Yeah, I was never a detective.
Okay. And was that in Florida, or where was that?
That was in Florida.
You testified to several theories and concepts surrounding use of force. Are you saying that all of these that you testified to today on direct apply to this defendant specifically?
I tried to explain probably verbosely the ones that I did think were relative. I think it was most of them. I don't know if I can take an inventory of all that I have said versus the theories that I was asked about. But yeah, these are common theories that I speak about in self-defense cases. They tend to be consistent when you're talking about the fight and what happens in the pre-fight ritual, what happens with threat assessment, what happens with the anxiety and how anxiety affects performance. All of those things are relatively consistent.
Okay, so specifically when we're talking about, you testified quite a bit on fragmented memory, memory distraction and memory loss.
Yes.
It sounded like you were saying that those things definitively apply to this defendant. Is that your testimony?
Again, I don't know what's going on in his head, but I do know that many of the cases that I have are often tried after the incident. In other words, the idea that somebody's lying must show proof of guilt, and I'm suggesting that it's not always the case, scientifically speaking. Loss of memory is not necessarily an indication of guilt. Now, is he lying about it? It's up to the jury to decide. I don't know. But there is an alternative explanation for why his memory would not be accurate. And I think it's critical to talk about this because most people feel like if I was in a situation like that, I would never forget it. And it turns out you would forget it because that's what happens to people who are actually in situations like this.
All right, I think we all understand that you're speaking generally. My question was, can you say definitively that those things apply to this defendant? I believe you just testified that you don't know what was in his head.
Yeah, I don't think you do either. I don't think any of us can say definitively what was in his head. I concede to that.
Correct. So it's possible that he was being untruthful about some things because he just wanted to be untruthful. Is that possible?
Sure.
Ultimately, you just referred to this, the jury has to follow the law in this case, correct? I mean, all these theories and concepts that you've described may be helpful, but ultimately, they do not trump the law. Is that right?
That is correct.
The jury has to follow the law in this case that the judge gives them?
Yes.
Would you agree with me, just speaking generally, and we'll focus more on this, this specific defendant, would you agree with me that a scenario involving mutual combat or a mutual fight between two individuals that have agreed to fight is different than one involving a one-sided attack? Would the analysis be different in that case?
Not necessarily, because it's on a continuum, right? You can volunteer to fight, and then in the middle of the fight, in an instant decide, okay, I'm retreating from this, I don't want to fight anymore. So when you're talking about violence, you're really talking about two different types of violence. One type of violence is known as acquisitive violence. This is also called predatory violence. Whenever you take an equation where there's a fight, and I'm not talking about a boxing match, that's a voluntary fight.
I'm sorry, I didn't mean to cut you off. Could object to non-responsive, Judge.
Sustained.
So you talked about a continuum. I believe that you were going to testify that it's possible to start with one understanding of a fight and then it escalates to something else. Is that?
Yes, that would be the nature of a force continuum, yes.
Okay, so for instance, somebody starting a fight with hands and then the other person pulls out a knife. Is that an example of that?
That would be a escalation of force on one side, yes.
Okay.
But it may not be disproportional. I just want to be clear about that. I mean, if you're a small person against a big person, you may need to be proportional with a knife.
Sure, and I will get to that a little bit later. Would you agree with me that the use of simple force and deadly force is two different things?
Yes.
Would you agree with me that using deadly force against someone who is using simple force is not proportional?
Not
Generally
necessarily.
speaking. Generally speaking.
Not necessarily. I can only say that. Again, you know, what is the use of deadly force is the belief that you're going to cause great bodily harm or death. The perception of why you should do that can be against simple force. So it depends on what the actor who's using deadly force perceives to be the danger. And if they believe that their life is in imminent danger of death or great bodily harm, then even if it's against, you know, the old idea of bringing a knife or a gun to a fist fight, is really sort of a misunderstanding of how we process threats. The way we process threats is how do I feel at this moment? Am I in danger? If you're in the middle of a fight and you fall down and you break your leg, you're not the same person you were just a moment ago. So you may have to escalate against simple force, things like that.
Okay. Would you agree with me, assuming that excessive force is present in the situation, generally speaking, would you agree with me that is objectively unreasonable?
From a legal perspective?
Yes.
Excessive force? Yes. I mean, excessive force is the one thing that I've spent most of my life trying to teach police officers not to engage in.
And we just talked about this, but would you agree with me that proportionality is an important factor in analyzing the use of force?
Yes, but there's a subjective standard.
Okay. So would you agree with me, just speaking again in general, that in a mutual combat situation, if one of the participants has a weapon, such as a knife, and the other does not, that the participant with the knife has an advantage over the other individual?
That's Generally speaking, what a weapon is for is to give you an advantage. Once again, going back to the aposematic threat, it's the idea that it is a show of force before it's a use of force in an attempt to de-escalate a potential attack.
Would you agree with me that a knife is a deadly weapon?
Well, it can be if it's used in a deadly way, just like a ballpoint pen can be a deadly weapon if you stick it in someone's eye, I suppose.
Sure, obviously in this case it was because the victim died, correct?
I'm sorry?
The knife used in this case by the defendant was a deadly weapon because the defendant died, correct?
Yes, so he used it as a deadly weapon.
Are you familiar with the use of deadly force in self-defense under Texas law?
Generally, I'm not a lawyer.
What's your understanding of it?
You may use deadly force if you believe that your life is in imminent danger of serious bodily harm or death. There are some additional features under Texas law involving property and things like that.
And you just alluded to this, but the standard here in Texas is a reasonable person, correct?
Yes.
So it's not necessarily the defendant just saying that I was scared, correct? There has to be an objective standard.
Well, it's an objective, subjective standard. I mean, you have to look at it through the lens of the individual that's using force. Otherwise, the legislature has not been kind enough to give us a force continuum as they have in law enforcement. It says, if they do this, then you may do that. Law enforcement has got all that figured out. That's not in Texas law. So the construct of objective reasonableness is something you kind of got to figure out while you're in the middle of a fight. And you're doing that from the lens of a subjective analysis. In other words, what do I think is happening to me? And is it reasonable that I think that's happening to me? So it's an objective, subjective standard.
Again, it's from the standard here in Texas is a reasonable person. Of course, that person you put yourself under the same circumstances as that person.
That's right.
But the standard is a reasonable person across the board. Is that fair to say?
The part you said earlier was the subjective standard. You have to put yourself in the shoes of that individual to make an objective analysis, yes.
Correct. Did you interview any witnesses in this case?
The defendant.
Okay, and when did that occur?
Earlier in the year, several months ago.
Approximately, you remember what month or?
I think it was around March. I think that's what I said to you last time, but I don't recall exactly.
Okay. And about how long did you meet with him?
Just over 3 hours.
Who else was present?
The attorney,
Which one? I'm sorry, there are two on there.
Mr. Patton, sorry.
And you testified on direct that your starting point in this case was assuming that everything that the defendant said was true, correct?
Well, everything that was given to me was true, and that goes to Ms. Bass' statements, that goes to the information that law enforcement had put out in the record. I just assume all that stuff is true. I do look for conflict. I look if there's something that just simply can't be true. For example, if the video shows something and something that someone says doesn't comport with it, then I would point that out. But I assume everything is true strictly for the purpose of analysis.
So as it pertains specifically to the statements of the defendant, both to the police and in your personal interview with him, did you find anything inconsistent that he said?
Well, yes, I mentioned that he believed that the decedent in this case was driving, and that's not true. I mean, I think we know that. There may have been some other inconsistencies, but they don't come to mind. That was the one that really stood out to me and caused me to ask, why would he think that?
Okay, so that's the one that stood out to you. Let's go with a few others.
Okay.
You referred to the surveillance video. You've had an opportunity to review his police statement, correct?
I did, yes.
And do you recall in the statement that he said that he pulled up behind the victim's vehicle and he waited there for a couple of minutes?
I don't think he said minutes. I think he said 10 seconds or something like that, 10, 15 seconds as I recall.
If you can give me one moment, Your Honor, I'm going to pull up the video real quick.
just,
Question, I'm sorry.
go ahead,
Good
John.
job. Am I under arrest right now?
You're not under arrest right now.
I'm not under arrest at all, so I can leave.
Sorry, Your Honor, for the record, I'll just say I'm starting the defendant's statement at a runtime of 10 minutes and 20 seconds.
To leave, yes, I would prefer you not.
Yeah, but I can leave if I
Yeah.
wanted to, right?
Right
I
now
can
you
just
can't,
walk
yeah.
out freely.
Right now you can't.
Okay,
Yeah.
alright.
All right, where's yours, man?
Well, I went to go get some Whataburger.
Okay.
Came back, there's a car, vehicle in front of me. All right,
You
cool.
remember what time that was?
I don't.
You live at Guerrero, at the apartments on Guerrero?
Yes, sir.
Okay,
Yes.
what apartment number do you live in?
7-Eleven.
Okay.
Easy to memorize.
Okay, gotcha.
7-Eleven, right?
Gotcha.
Yeah, so vehicle was in my way. Well, I don't want to say my way. In front of me. Waited a couple minutes.
Waited a couple minutes, correct?
He says that here, but there, at some point, he does narrow that down to like 10 or 15 seconds. I don't know where this tape he says that, but I most certainly did hear that. By the way, he doesn't wait for 10 or 15 seconds as far as the tape goes. It's much quicker than that.
I don't recall him saying that, but he says here that he waited for a couple of minutes, correct?
Yeah, he does say that, yes.
Okay, based on the surveillance video that you reviewed, that is incorrect, is that
That is
right?
correct, yes.
He also stated that he could not go left or right. You recall him saying that in his vehicle because the complainant's vehicle was blocking his path?
Yes,
That was incorrect, correct?
I don't know that.
You watched the security camera video, correct?
I did, yes.
Okay. I'm sorry, for the record, for the security video, we're starting it from the very beginning. So Dr. Bedard, we're looking at the complainant's vehicle pull up first, correct?
Yes.
And then we'll see the defendant's vehicle pull up here in a few seconds. Was it true or untrue that he could go around or go left or right?
He did pass them, yes.
Okay, so that was untrue, correct?
Yeah, I'd have to hear the context of him saying I couldn't go left or right, because this was a changing scene in the cars that backed up and moved forward. I don't remember exactly when he said that.
Well, he's saying it from the beginning, correct? He says that he got there, he pulled up, that the vehicle was blocking his path, that he waited for a couple minutes, he honked, and he could not go left or right.
I'm happy to watch it if you want to show me that segment. I mean, it was a fairly long interview, and they not only asked the questions as law enforcement does, but then they came back and they got more clarification. So I don't recall precisely at what point he's talking about.
You already pointed out that it was untrue that he says that the victim was in the driver's seat, correct?
Yes.
You recall the defendant saying that he had never seen either the victim or Ms. Bass before?
I do recall that.
Were you aware that he had met the defendant, I'm sorry, that he had met the victim and Ms. Bass before and actually had conversations with them?
I'm still not sure if he remembers that. I think Ms. Bass said that, and she said that he lived above them or below them. I don't remember. So clearly they had contact. That doesn't speak to his state of mind, that he doesn't think he knows them.
Okay, you had mentioned that these inconsistencies you felt like didn't give him, I think maybe you were just referring specifically to him mixing up the driver and the passenger, that you wouldn't see any reason for him to lie about that. Is that correct?
I didn't see if it was self-serving. Perhaps it was. I don't know if it matters where Mr. Mills came from, but rather that at some point he was there.
Would you agree with me that inconsistencies like that go to his credibility, the defendant's credibility, and whether or not he's being truthful?
Yeah, so this is exactly what I was talking about. You know, in psychology we have it called attribution theory.
I'm gonna object to non-responsive. This is a yes or no question.
Sustained.
Okay, no.
Would you agree with me that saying, mischaracterizing whether or not he can pass in this situation is self-serving? I mean, wouldn't that benefit him to say that he cannot pass in this situation?
Yeah, I could see that he may have some self-serving interest in saying that. Again, it's contextualized. When does he say this? When is he referring to it?
Okay. defense counsel asked you about the Instagram video, the complainant cell phone video, and you alluded to this on your testimony when you asked you about this. In the moment, we see the defendant sitting in the vehicle, and he's not being, you said, I think, antagonized by the victim, and he's not doing anything, but you also admitted that you don't know what happened before or after that. There's no video showing what happened before.
I mean, we have the recording of the 911, you can hear it's a much longer event than what we're seeing on the Instagram video, but I can't say with any degree of certainty precisely what happened before or after what we have captured on that Instagram video.
I guess my point is, it's possible that the defendant could have been the antagonist at some point. Is that possible?
Sure.
Okay. There was testimony about a person being in a vehicle and being at a disadvantage. I think you used the term sitting duck.
Yeah, perhaps. I mean, it's just sort of using police jargon, if you will. But yes, you are at a disadvantage in a motor vehicle if you're sitting there.
Okay, so if you're sitting in a running motor vehicle and a threat encounters you, you're saying that it's better to get out and approach the threat as opposed to leave?
So I didn't say approach the threat. What I said is to get out of the vehicle for mobility purpose, right? So there's, in threat assessment, you want two things. You want concealment, you want cover. You want to be able to get behind things and hide, you want to get behind things and stop bullets. So if you're in a car, you have neither. Cars are not good concealment, and they're even worse for cover. So the theory of getting out to make yourself more mobile so that you can run for that close tree, or you can run away, or you can engage, those are things that first require that you get out of the vehicle. So it's almost intuitive to do that. We do teach it as a standard in law enforcement. Certainly if you have incoming bullets, which law enforcement has faced behind the steering wheel, it's better to be out of the car.
So in a situation where you're in a running vehicle in an open space and you feel like there's a threat, it's better that you get out of the vehicle as opposed to having the opportunity to leave. Do that? Is that
Drive
my
away?
understanding? Yes.
I suppose it's an option, but again, we have a vehicle that's sort of pulled in here at an angle. It's not a quick flight. It's a maneuvering of getting the ability to, I think, get back on track and get out of there. Certainly there's no legal requirement for that, but
Sure.
even if there was a legal requirement for that, I think you're talking about milliseconds here. Quickly getting out of the car and making yourself protected from getting behind something, if suddenly a gun did appear, for example, would be smarter than trying to put your car in reverse and back out and try to get back in that lane. Those things take too long.
I understand. You're throwing guns into the situation. Is there any information in this case that a gun was presented by the victim?
Well, the information comes from the prediction, like what do I know is going to happen versus what do I expect is going to happen.
Is there any information that you received that the victim had a gun in this case?
I don't know if he did or he didn't.
Is there any information that you received from the defense attorney in this case? That
In the
victim
hindsight of
had
the
a gun?
event, no.
I'm sorry?
In the hindsight of this event, there was no information that I have that a gun was present.
Sir, at the beginning, when you were hired by the defense, and
Yes.
while you were reviewing evidence in this case,
Yes, ma'am.
were you given any indication that there was a gun involved?
No, I had the benefit of hindsight. There was no gun involved as I knew it. I was looking at it from the perspective of the defendant at the time he was making those decisions.
I'm just asking you, do you have any information in this case that the victim had a gun? That's all I'm asking.
I don't have any information on that, no.
Okay. You have any information in this case that the victim had any weapon whatsoever? Yes or no?
I'm thinking, so many things can be used as weapons, including your car, but the answer is no handheld weapon, no.
You testified that you listened to the 911 call in this case,
I did.
and I believe you also testified that you can hear the victim on the 911 call say he has a knife, referring to the defendant.
Yes, sir.
Would you agree with me that at the point in time that we hear the victim say, oh, he has a knife, there's only seconds between that and when he's stabbed?
Yes.
Do you hear any threats on the 911 call, such as, I'm gonna kill you, I'm gonna beat you up, anything like that that you heard on the 911 call?
I couldn't make it out, no.
You're aware that the defendant stated that he showed, and I think you testified to this, that the defendant claimed that he showed the knife to the victim prior to the physical altercation?
That's my understanding of his statement, yes.
Did you hear anything like that on the 911 call? Did you hear the defendant tell the victim, I have a knife, I don't want to fight, anything like that?
I'm not sure he ever said that he said that, but that he showed it to him.
You testified that the victim goaded the defendant out of his car, is that
Yeah.
correct?
Yes.
Did the victim force the defendant to get out of his car?
Physically forced, no. I think there was some coercion based on the fact that there wasn't much that the defendant could do. If he parked his car in some location and went to his apartment, he'd still not be safe, since he knew that he had an antagonist who could see where he lived, and he was on open social media. Who else was coming? We don't know.
So again, going back to sitting in the car and getting out as opposed to driving off, I mean, all the factors that you just listed, I think that a reasonable person in that situation would drive away as opposed to stay, correct?
So I don't know. I
I would
think
also object to the form of the question, what the prosecutor thinks is reasonable in this situation. It's not an appropriate question.
I'm asking his opinion, Judge.
Overall, this is cross-examination.
Yeah, I think he lived there, so certainly he's entitled to be there. I don't know where else he would have to go. That being said, I think it was safer for him to get out of the car than to, as I said, maneuver the vehicle, and perhaps, given the fact that he didn't know this individual was armed, receive gunfire from the rear, who knows?
So better to take gunfire in the car than gunfire outside of the car? Is that what I'm
Better to be
understanding?
behind the car, behind a tree, or 30 more yards down the road when you're shooting than to be sitting in the front seat of the car when somebody's firing at you.
So you talked about the size difference, and you talked about how a person would assess that situation, whether they want to take on a person that's bigger than them.
Yeah, from the perspective of self-efficacy, it's generally understood that smaller animals don't attack bigger animals unless they're in groups.
Sure, so in this case, the defendant made the decision that he felt like he wanted to engage the larger person, correct?
I think what he's trying to do, what he says, is to present a threat display, hoping that this would cure the situation, have the individual think, the cost of pursuing this is too high, I should get in my car and perhaps leave.
So the answer is yes.
I don't know what he was thinking, but that's what it appeared to me, that's how I analyzed it.
So yes, that the defendant made the decision to engage with the victim, correct?
It's a trick word. Again, he did not physically engage him. That was not his decision to do it, but to engage him outside of his car with the presentation of a weapon.
You're aware that the defendant told the police that he saw the victim walk over to the field, correct?
Yes.
At that point in time, the victim had already made plain to him that he wanted to fight him, correct?
I don't know that. I know that he was starting to prepare himself for a fight. He was pulling things out of his pocket. I don't know how that spoke to the defendant. It appeared to me as if the defendant believed the fight was about to occur.
Okay. And the defendant made a conscious decision to get out of his vehicle and go to the field as well?
Yes.
With that knowledge, correct?
Yes.
Okay. You wouldn't say that that would be engaging?
No, I think this was resolution. I think he lives there. He's got to park his car at some point, and he wants this resolved. He told me, as we were speaking, he was waiting for the police to show up. And not to sound crass, but there's a saying, that when seconds matter, the police are only minutes away. And I think that's what he was experiencing, was that they weren't getting there quite quick enough, and this needed resolution. Perhaps doing a threat display, getting this individual to concede that this fight wasn't worth having would have been the best remedy. That's what I understood from his speaking to law enforcement, what he had planned.
You said that he told you that he was waiting for the police to show up?
Yes.
At what point, did he indicate at what point in the situation?
He said that he was aware that Destas had called the police, and so he said, sort of in the back of his mind, he was anticipating that they would be coming.
You talked about arming yourself with a knife as, I forgot the term that you used, but basically as a defensive tactic.
As an aposematic threat. Okay.
But I think you acknowledge that it's also possible that presenting a knife to somebody could also be an act of aggression as well. Yes,
Yeah,
ma'am?
yes. I think that can be, yes.
Yes, thank you. And just to follow along that thought, can it also be an act of intent to use the knife?
Yes, that's why the bluff works. So whether you do or you don't, I mean, time will tell, but the other person has to believe that you are being aggressive and you will use it. That's how it works.
So when you were talking with the defense attorney about hands being a deadly weapon, he also threw feet in there. I just want to make it clear that do you have any information that the victim in this case used his feet against the defendant?
No.
So you are aware that at the point in time that the defendant used deadly force against the defendant, that the victim did not have a weapon in his hands. I think you acknowledge that. No weapon in his hands as far as that's concerned.
Yeah, yes, there was no additional weapon. I mean, the hands are weapons, but there was no additional weapon in his hand.
And you're aware that the police, during the course of their investigation, never found any type of weapon, correct?
That's my understanding.
So you come to the conclusion that the defendant's use of deadly force in self-defense in this case was justified, correct?
Yes.
What unlawful deadly force was the deceased victim, Mr. Mills, using or attempting to use against the defendant in this case?
Well, as I mentioned, the perception of deadly force comes from what happens after you connect with my head.
I'm asking you what attempted use of deadly force or use of deadly force was the victim using against the defendant when the defendant stabbed the victim?
He swung at his head.
With a fist?
Yes.
That's the deadly force that the victim was using against the defendant to justify the defendant stabbing the victim?
Well, the
Swinging
defendant had a
fist.
knife in his hand, so I mean, you have to take this to its logical end, right?
I'm
So
sorry?
The defendant had a knife in his hand, and I said, you have to take this to its logical end. Certainly, if any weapon is introduced, there is now a weapon in the fight. So
But
for
the
example,
defendant introduced the weapon, correct?
he did, and if he lost control of the weapon, the simple punch could have turned into something certainly more severe for him.
If he would have lost the weapon, that would have been his fault because he presented it,
If
correct?
he got punched in the face, I don't know it would have been his fault. He was using it as a threat display.
Okay. But you agree with me that it's up to this jury, after hearing all the evidence in this case, it's going to be up to them to determine whether or not the defendant used lawful self-defense in this case, specifically deadly force in self-defense, correct?
Yes.
I'll pass it, Attorney.
Thank you, Your Honor. Dr. Bedard, in your review of this case, did the inconsistencies that opposing counsel highlighted, did those change your analysis of the 911 call at all?
I'm not sure I understand your question.
Were the inconsistencies part of the 911 recording? Any of the items that he pointed out as being inconsistent in this story, were those even relevant to the 911 call?
I don't believe so.
Like the surveillance videos that we don't have about the minutes before or the minutes after, we still have the 911 call.
Yes.
And the 911 call captured what happened in the moment.
Yes.
And the decision is decided in the moment.
Yes.
The Instagram video, same analysis, right? I mean, all these things that they've pointed out, the Instagram video speaks for itself. Is that fair?
It does, and it provides some form of evidence. Rather than dealing with possibilities, the Instagram video alluded to a probability of antagonism, for example. I don't like to deal with possibilities when I'm doing my analysis. I realize they exist when somebody's trying to imagine what might happen. What are the possibilities? What if he takes this knife from me? That's a possibility. But for my analysis, the probabilities matter, and information like the Instagram video was helpful to see, at least for that moment in time, who was the antagonist.
And opposing counsel discussed, and we watched a little bit more of the interrogation video of Mr. Rodriguez, are you aware of him asking law enforcement officers if they saw the video?
Multiple times. As I
And,
recall.
go
I said,
ahead.
as I recall, I think it has to be at least a half dozen times.
And in your 3-hour in-person interview with Mr. Rodriguez, do you recall how he explained what he meant by that?
An objective hearsay, Your Honor.
What's the defendant's response?
Well, pursuant to 703 and 705, he is allowed to rely on otherwise inadmissible hearsay. He relied on this in forming his conclusion, and it is already been elicited through testimony both on direct and cross with Detective Chevalier that there is some question about some video that is not in evidence. And so we believe that it's highly relevant to the analysis of the situation through his expertise and evaluation of this case to help the jury understand what Mr. Rodriguez was thinking whenever he was asking law enforcement over and over and over again, did you not see the video?
Judge, the law is very clear that any statements made by the defendant, offered by the defense is hearsay.
I'll let you ask, elicit that response. However, the jury is not to necessarily ascribe any truthfulness to that underlying hearsay. It was just a basis that helped Dr. Bedard get to his conclusion or perform his analysis. Go ahead.
Dr. Bedard, do you recall that he believed it had been videotaped
Yes.
and that he believed he had seen a light from Ms. Bass's phone reporting the incident?
He did say that, yes.
And is it your recollection from your interrogation with him that that's what he kept asking law enforcement about?
Yes.
So if you believe, well, and I want to move forward a bit, but I want to connect it to this thought. On cross-examination, there was a discussion about the proximity to the home and the right to be there. On our direct, we went through we went through all of the analysis, right? But one of the points we didn't touch on is how does proximity to one's home enhance this sort of perception of the threat when you're 200 feet line of sight from your front door and he's having to make these decisions. Do you have an opinion or did that play into your analysis at all on what he may have been thinking in that moment?
Well, he told me what he was thinking, and I thought it was reasonable, that had he moved at that moment into his apartment, he still wasn't safe. He was concerned that the social media was still on. He didn't know if it was a small clip or a long clip, and that perhaps friends might be coming to the area. Now he has his apartment door being opened within eyeshot, and everyone knows where he is. That's what he said. I thought that was a reasonable threat assessment, that he couldn't go into his house at that moment.
Judge, if the witness will be allowed to continue to testify to statements of the defendant, I would ask for a wording objection.
I'll give you an objection.
Thank you, Your Honor, and I'll modify my questions a bit. I'm sorry. Could Mr. Mills have pursued him home if he had gone back to his apartment for safety?
I don't see why not, yes.
If he had left in his vehicle, in your experience, would it have been possible for Mr. Mills to pursue him in a vehicle?
Sure.
Did Mr. Mills have access to the vehicle?
Yes.
In these situations, how is a person supposed to know when it's safe to come home after you've been threatened on your front yard?
Yeah, you're making predictions about that based on those strong signals in the environment, and the signal suggested it wasn't safe.
Does the presence of children potentially in the home, or even dogs, things that you love, does that enhance the anxiety arousal interpretation for the mind in these critical moments?
I object to relevance and speculation, Your Honor. Again, I suspect that these are statements from the defendant that he's trying to work around. I'm going to object.
May I respond to that, Your Honor?
Go ahead.
His having children at that home and dogs was all in his recorded interrogation that they presented as state's exhibit through Detective Chevalier. I'm not getting into any hearsay statements I've been very careful to modify my questions moving forward, not to violate your ruling a moment ago. This is all in evidence from the state.
The objection's overruled. Go ahead.
So if someone has children in the home, is that applicable to a anxiety arousal analysis or a threat, processing a threat in that moment?
Yeah, it's obviously a deep concern. I think before you present where you live, it doesn't become an anxiety because you don't anticipate they're going to go there. But your concern for presenting where you live, if there are children in the house, would create a new anxiety, or it would magnify the existing anxiety, sure.
On cross, there was a bit of conversation about proportionality. It's undisputed that hands can be a deadly weapon.
That's right.
It's the manner and means in which they are used.
Yes.
And the size comparison is part of that analysis.
Yes, I mean, I think on average, people think that someone bigger than me will do harm.
You were also asked on cross-examination whether or not it's the jury's job to follow the law regarding self-defense in this situation. Do you recall that question?
Yes.
Could you explain to the jury what your understanding of Texas self-defense law is?
Yes, I think I did.
This has been asked and answered, Your Honor.
Sustain. Let's not go back over the same testimony. Move on.
The purpose of your testimony here today is to assist this jury in following the laws of the state of Texas.
That's not the purpose of my testimony. I think the judge will give that instruction on what the law is, and they'll be expected to follow it. My purpose is to describe how, on average, people react when they are threatened. I'm not a lawyer. I'm not here to tell the jury what their legal opinion should be with respect to whether or not this defendant broke the law and should be convicted or acquitted. That's not my job. My job is to merely talk about how humans react under threat, and the circumstances that are not commonly known, not well known to people, are what I hope to assist the jury in understanding. That these things, having talked to, I don't know, probably well over 1,000 people about similar incidents, and having been in a shooting myself, I have a understanding of an area of life that fortunately most people will never have to experience themselves.
Thank you. No further questions, Your Honor.
State.
Just briefly, as pertains to the, you said that you're familiar with Texas law as pertains to self-defense, self-defense.
Your Honor, I'm going to make the same objection the state just made. This has been asked and answered on the Texas law of self-defense with what you just objected to.
I haven't even asked the question. You said you're familiar with Texas law as it pertains to the use of force and self-defense, specifically the use of deadly force. Is there a difference, or there is a difference between deadly force and self-defense used by law enforcement as opposed to civilians, correct?
Depends. So law enforcement uses force for 3 reasons. One of them is to make arrests, one of them is to prevent escapes, and the other one is in defense of self or others. The first 2 is different, the last one's not. There's nothing that a law enforcement officer can do that a civilian can't do to protect themselves, with the exception of training and equipment. If they're equipped, obviously, like a law enforcement officer, with various tools, which most civilians aren't, then they would be limited in their response. But otherwise, the self-defense component is a natural bridge between law enforcement in a state like Texas, where there's no duty to retreat. There's a natural bridge between the law enforcement and the civilian when it comes to self-defense.
So you just mentioned this, but there are specific exceptions specifically for law enforcement as pertains to the use of deadly force and self-defense, correct?
Well, law enforcement does not use deadly force to make arrests. They use it if they are in the process of making an arrest and the situation turns deadly. But I mean, clearly after Tennessee versus Garner, the use of force to...
My question is, there are special exceptions in the law for law enforcement to use deadly force in specific situations that do not apply to civilians,
Your
correct?
Honor, I'm going to object to relevancy. The applicability of the use of deadly force by law enforcement has no material, like, it doesn't tend to prove or disprove any material fact or consequence in this case.
Your objection's overruled. Thank you. Go ahead.
I'm sorry, did you answer the question?
Would you re-ask it if a
Yeah.
little disrupted?
I believe you just testified to this, but there are special exceptions in the law that gives law enforcement specific situations where they can use deadly force where civilians cannot.
That's a different question you asked me before. You asked me in relationship to self-defense is what you said, and that's why I answered the way I did. Yes, there are other exceptions. Arrests and preventing escapes would be additional areas of use of force that civilians don't engage in.
That is under the self-defense statute here in Texas, correct?
I'm sorry?
That is under the self-defense statute here in Texas?
The self-defense statute does not talk about arrests and preventing escapes.
That's what you're.
Defense,
Brief redirect, Your
go ahead.
Honor. In your training experience, are law enforcement officers trained to display a weapon to de-escalate situations?
Yes. I wrote an article on that specific fact that law enforcement officers most often draw weapons and reholster without shooting anyone on the order of thousands of times across the country versus the actual number of times that they shoot.
Thank you. No further questions, Your Honor.
Any other questions?
Never further, Your Honor.
May this witness be released?
No objection from the
Yes,
state.
Your Honor.
All right, thank you.
Thank you, Your Honor.
Defense, call your next witness.
Could we have a moment, Your Honor, to confer with our client?
Would you like to confer here, or would you like to go in the?
May I
work order?
approach, Your Honor? May I approach?
Yes, you may. Do both sides rest and close?
Yes, Your Honor, stay close.
Yes, Your Honor.
All right. Ladies and gentlemen, you now have all the evidence in this case, but you don't have the court's charge yet that will give you the law that will aid you in deliberating guilt or innocence. And so I'm going to give you a 15-minute break while we work on the charge and see whether we can have closing arguments today. Okay? So let's be back here about 3:55. Okay? All right.
All right.
Rodriguez,
Yes, ma'am.
if you would stand up for me, please. All right, raise your right hand for me. Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, ma'am.
All right. Now, the state of Texas, your defense team rested their case without putting you on as a witness for testimony. Now, Mr. Patton represented to the court that he discussed with you during one of our breaks or so and asked you whether or not you wanted to testify. Now, you do understand that you have an absolute right to testify on your own behalf. And if you choose to testify, the state can cross-examine you just like any other witness. You understand that?
Yes, ma'am.
Test your credibility, just the way they tested the credibility of every other witness that testified. And so, is it your position that you do not wish to testify to? And I'm not asking you because I'm trying to make you testify or not. I just want it to be clear for the record that you understood that you have a right to testify or to remain silent. You understand that?
I understand.
Okay.
Yes.
So is your attorney correct in saying that you have chosen willingly and of your own decision not to testify in this case? Is that right?
Yes, ma'am.
And nobody has forced you to make that decision, correct?
No, ma'am.
Okay. All right. Do you want to add anything else to that, Mr. Patton?
No, Your Honor.
All right. Off the record. The jurors are present and seated. Ladies and gentlemen, we've been working while you were in the jury room, and it's kind of late, and so I'm going to release you all for the day. I'll present the charge to you in the morning when you're all fresh, and then that's when the closing arguments will happen, okay? So you are still under my instructions, even though you have all the evidence right now. You don't have the charge, you don't have the closing arguments. So don't deliberate, not even in your own heads, until you've heard everything tomorrow, okay? Don't chat with anybody about what's going on, and we will see you early in the morning at 9 a.m. Thank you all so much for your patience.
All right.